The system's rigged, man, it's time to break free. Eyes wide open, gotta see what I see. Standing on the front lines, fighting for the truth. Lift the veil of lies, it's time to be the proof. Take a stand, don't you back down. Raise your voice, let's shake the town. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people, we'll make them see a world of justice, united and free. United and free.
Assembly to call Ms. Thompson and tell her we are waiting on her, that she needs to get here, that the trial is on hold until she gets here. And so I will await a call back from her as to what that status is. In the meantime, with the directed verdicts, directed verdict for David Booker on counts 3, 6, 9, 12, and 15 is denied. I pulled the transcript, and I believe the gang expert did testify that if Mr. Booker participated in this crime, it would increase his status. Directed verdict of Mr. Collins by Mr. Clegg on all counts is denied. I find there's factual evidence that should go to the jury. On the directed verdict made by Ms. Drake on behalf of Ms. Hewley, where Mr. Clegg joined Mr. Collins and then Mr. Lewis joined Mr. Booker. On count 10, I have reviewed all the law that Ms. Drake cited, Jackson v. State, Bradford v. State, and Holloway v. State, and those are not on point, so I'm denying all 3 of those directed verdicts. The housekeeping that we could get through while we're waiting on this juror, defendants 9 through 14, which I think were all used by Ms. Drake with Detective Harrison. Those are admitted for the record?
I did not admit them.
No.
I spoke to Mr. Melvin. I can certainly admit those for purposes of the record, just as a reference.
Tender.
What did I say?
Admit them. I'll admit them. You tender them.
I'll tender them.
I just wanted to make sure, that we had those in, and Ms. Drake, if you will get those to Sheila, and all defendants 9 through 14 are admitted only for the record.
Yes, ma'am. And may I get those to her in the morning? I believe they're in my notebook that
Yes, they were in your notebook that you showed Detective Harrison. That is fine. And then Mr. Melvin, we had gone through, I think, through exhibits just to make sure when we had some downtime, we went over exhibits, and you put a couple more. Do you want to go over those?
Yes, ma'am. And I believe Ms. Crepperson may have an answer for us.
Oh, yes. I didn't see her. I'm sorry.
Sheila, where did we leave off in our original? Was it like
Okay. Juror number 6, jury assembly contacted her. She doesn't have money to get the alternator fixed on her car, nor does she have money to Uber here. She'd be happy to come if someone would give her a ride, but I've also contacted the sheriff's department, and I can't use the deputies for transportation. I can use them for contempt. I can send them out and get her if she's in contempt. So I believe we're going to need to excuse juror number 6.
15, Judge?
Well, 15 originally, but she was J6 on the panel. She was J6 on the panel, but juror number 15 originally. And then that would mean that juror originally 35A1 would go in, and that is Rock Lamar Desai. Was that what, yeah, okay. Because I don't believe under these circumstances, she's certainly not in contempt, but the sheriff's department cannot be used for transportation. So, with that, I believe we're ready to go forward.
Can I just have 2 minutes, Judge?
Certainly.
2 minutes.
Sir, are you an attorney? Oh, I'm sorry. The deputies, can they be on that? Okay, never mind, I'm sorry. Yes.
Yeah, step out.
Yeah. request for Mr. Booker, is that correct?
Yes, thank you, Judge.
Okay, and you need Apple TV, right?
No, not right now, Judge.
Okay,
You can leave it up for now, but that's fine.
you want me to leave it up?
and it's gonna be some pussy. Now the real niggas gonna be the ones with money and bitches.
So I don't have the prosecutor. I don't have a problem with the prosecutor standing here and standing over David Booker. But stand over what it is. He's been dead ultimately since '96, shot dead in Las Vegas. So when the prosecutor stands here and tells you that my client represents the depravity of rap, this is what I want you to think about right here, because he was at the most recent inauguration, Rick Ross. Ladies and gentlemen, I could play you a minute to a minute and a half of rap, give you a different artist for the next 7 hours, all of them nationally recognized folks. There's no scalpel sharp enough to separate David's rap from the depravity of the cultural rap that he was raised on. So when you sit here and the prosecutor plays this, oh my God, this is so shocking. It can't be shocking. His tattoo, as the prosecutor's already indicated to you, mimics 21 Savage. People want to be more than they can be. And while we can name in the black community 500 rap artists, we can't name 5 surgeons. I'll give you Ben Carson. We can't name 5 surgeons, 5 architects, but we know 500 rappers. And it doesn't matter that Ephesians 29 reads, let no unwholesome talk come out of your mouths, but only what is helpful for building up the one in need, because they played what they call the clean versions in church. Clean version, yes, that's where they removed the actual profane words, but the profane concepts are still played in the black church. So, if his depravity is reflected in his music, then all of American black culture is depraved. That's the end of that story. So all that good person, bad person talk that the prosecutor's talking about, and prior crimes evidence, and gang evidence, and rap evidence, cumulatively that tells you, the jury, the only thing that you need to know. The prosecutor himself has some doubts about the strength of the actual homicide case. The actual homicide case. That's what the rest of this is about. You can turn off the Apple Play. Thank you, Judge. He needs you poisoned against my client so you'll lower the bar of reasonable doubt so he can ultimately hurdle it. How many witnesses were called, ladies and gentlemen? 21 ultimate witnesses were called by the state. The defense didn't call any witnesses, and that should make sense that we don't need to call any witness because we don't have to prove anything. The judge is going to tell you when she gives you the instructions in regards to my client that he never needs to get on the stand and testify. You can't ultimately hold that against him. The state called 21 witnesses. How many witnesses put my client into QT? 0. How many witnesses testified about David's fingerprints or his DNA being at the scene? 0. My client never made any admission to the police ultimately when they spoke to him, and he spoke to the police about being at the QT, and you've seen absolutely 0 text messages to or from David regarding any participation in any type of slight or crimes. In fact, no one puts David near the Mercedes at issue that was involved in the QT homicide any time around the time of the homicide. The only photos you have with my client being near the Mercedes is at the Texaco 36 hours prior to the shooting. David paid for the insurance for the Mercedes. Yeah, I got you. I understood that. I heard that. David and Miles Collins know each other. That's what Miles Collins' girlfriend told you, that they both know each other. His cell phone pinged off a tower near the QT. Yes, if near is 2 miles, and you understand the tower to be out 2 miles, yes, my client's cell phone did ping off the towers. But David is on social media, super animated with the extendo clip in the gun. You want some more of that? I can give you another 2 hours of that. Why would he be doing that? Why would he be doing that? That's all David knows. That's all he knows. Yet none of that, the social media, the prior crimes evidence, none of that should be enough ever for you to find him guilty of homicide. One of the best things about going first is where there are 2 other lawyers, and you've seen those lawyers during the trial. I don't really have to worry about missing something on behalf of David, because you've already seen Mr. Clegg. He's super thorough. He's going to get up. He's going to speak to you after I sit down. And then Ms. Drake is going to get up, and she's going to speak to you. And ultimately, then the prosecutor, he's going to have the last word before the judge reads the law to you. And you have the evidence that you have. The only question you're going to have to decide is what was David's participation. The judge is going to give you the law when the prosecutor sits down. And we're all in agreement about the law that the judge is going to read to you. The judge is going to read you the law about reasonable doubt. The judge is going to tell you that reasonable doubt is a doubt of a fair-minded, impartial juror honestly seeking the truth. That's why we took so long to pick the jurors, because we got to find fair, impartial jurors. We got to find people that see gang and then don't pass out. Oh, gang, done. What do you want me to find them guilty of? Right. We don't need those folks. We also don't need the folks that say, oh, did the police pull up? Oh, therefore the police are wrong. If the police are speaking, then the police are liars. We don't need that. So we have to get a fair-minded, impartial juror. And reasonable doubt is a doubt of a fair-minded, impartial juror. It's a doubt based upon common sense and reason. That's what the judge is going to tell you. And the judge is going to tell you it does not mean a vague or arbitrary doubt, but a doubt for which a reason can be given arising from the testimony, the lack of testimony, or the conflict in the testimony. I don't know if you're going to consider David wearing the sweatshirt with the blue in it at the Texaco 36 hours prior to the shooting. I don't know if you're going to see that as a conflict in the evidence. Are the Bloods allowed to wear anything blue? I don't know what you're going to think about that, but ultimately that may be deemed a conflict in the evidence in regards to David being in the gang. Identification is a question of fact for you, the jury, to determine who ultimately was at the QT. And obviously Mr. Clegg brought out the fact, well, how many people are in the vehicle? Well, the prosecutor says it's 3 because there's 3 people sitting here, but there's nobody to tell you that there were 3, 4, 5, or 6 6 people ultimately in that vehicle. Identification is a question of fact for you, the jury, to determine. The judge is going to read to you some of the factors that you can consider when assessing the reliability of identification. I don't think they're going to be really helpful to you, but she's going to read it to you because the factors that go to assessing reliability of identification typically come when there's an eyewitness that's actually putting someone at the scene. So the judge is going to tell you the opportunity of the witness to view the alleged perpetrator at the time of the incident. Well, you already know that's not David. The judge is going to tell you the witness's degree of attention towards the alleged perpetrator at the time of the incident. Nobody showed any witness any photo spread where they picked out David and said, yes, I think that he was there. The judge is going to talk about the possibility of mistaken identity as an assessment of reliability of identification, but nobody ever identified David. What the judge is not going to tell you is digital DNA is a factor. Digital DNA. Yet nobody's going to come and tell you that. What did the DNA expert tell you? When I ask her, I've never heard of digital DNA. Right, it's just something that was created for effect, for dramatic effect. The term digital DNA. When you look that up on any sort of Google after the trial is over, you're going to see there's no such thing. It's made up. It's made up the same way the theft by receiving is made up when my client is sitting in the car and not ultimately behind the wheel. The judge is going to tell you that intent is an essential element of any crime and must be proven by the state. My client had to be present, and my client also had to have an intent as a party to a crime. And we'll talk a little bit about ultimately what party to the crime is. The judge is going to tell you grave suspicion is not enough, and I hope that makes sense to you. She's going to tell you mere association is not enough. What that means is the fact that David knows Miles Collins is not enough for you to convict him, and I hope that makes sense. And when she tells you that, David Booker knowing Miles Collins is not enough to convict David Booker. I'm hoping it also makes sense to you that fact that David Booker purchases insurance for a vehicle some 36 or more hours prior to the homicide, that doesn't put David Booker in the homicide. Mere association is not enough to convict David. Party to a crime. The judge is going to tell you what party to a crime is, and it's important that I read it exactly right. I suspect that Ms. Drake is going to give it to you also. Party to a crime. The judge is going to say every party to a crime may be charged with and convicted of commission of the crime, but you, the jury, determine if David ultimately is a party to the crime, not the state. A person is a party to a crime only if that person directly commits the crime. That means produces the firearm and shoots the victim. We know that's Josiah Hewley. Or intentionally helps in the commission of the crime. Again, mere association is a no-go. Intentionally helps in the commission of the crime. Purchasing insurance on a rental vehicle without more, I contend, is a no-go. Because it's not helping in the the law, party to a crime, is not about helping in a potential crime. It is helping in the crime, the aggravated assault, the hijacking, the homicide that occurred. And there's absolutely no indication that David Booker intentionally helped in the commission of the crime. The judge is going to tell you when you have multiple defendants that you have to determine the guilt of each defendant separately. And the judge is also going to tell you under the knowledge charge that the state has to prove that David had knowledge that the crimes of hijacking a motor vehicle or aggravated assault and felony murder were being committed and intentionally participated or helped in the commission of such crime. As you listen to the judge's charges, you're going to see that, didn't she just say that? Party to a crime, intent, reasonable doubt, multiple defendants. There's a complementary nature to the charges. She's going to tell you that in regards to credibility and the credibility of witnesses, the jury determines the credibility of the witnesses. This really wasn't a big credibility case. We know that there was a homicide. We know that there was a car involved. We know that at least 2 people got out the car, which probably left 1 person in the car based on how the vehicle left the QT. It's not a big credibility question of witnesses. The judge is going to talk to you about experts. You're not required to accept the testimony of any expert, any witness, expert or otherwise. I love it when the gang experts come, though. They told you, I thought he said 2/3 of all violent crime. That's what I thought he said. Sometimes I miss it, though. And then he told us on the stand under oath, is 2/3 of all crime. Let's say you believe that. 2/3 of all crime in Georgia is committed by folks that are members or associated with a gang. What's the next logical thing for you to determine? The next logical thing, you've got an association that's been around 10, 20, 30 years, and nobody is identifying the things that lead to people getting into a gang. You can't list those for me? Income below, people in the family not getting a certain amount of education. Maybe you already know what it is. Maybe you already know. Well, it's the music, but we can't say that. It's the music. If they listen to more than 7 hours of it a day, from the time they come out the womb till about the age of 20, they're going to end up heading that way. What did the gang expert tell us, though? The gang expert told us they have no idea. The organization has no idea what the factors are that lead to people being in the gang when the gang is responsible for 2/3 of all the crime in Georgia. That's almost as crazy to me when he says that as the church and the Falcons at Mercedes-Benz Stadium playing the clean version of what you just heard. That's almost as crazy to me. The judge is going to give you the charges as they relate to the gang statute. The judge is going to tell you that the state must prove that there's a nexus, that means a connection between the crime committed and the gang. That should be sort of silly to you. Why? Because he told you 2/3 of all crime is committed by the gang. That means that there's no crime that is committed that the gang would not commit. But that's the first part of the gang statute. The state must prove there's a nexus or connection between the crime committed and the gang. That's almost like that's a given based on the expert if you believe that 2/3 of all crime is committed. Then there's the second part. The crime was committed, the crime that was committed July 10, 2022, was to further the interests of the gang. That's where it starts to get a little shaky. You're a gang member, so if you commit a shoplifting, is that to promote the gang, or did you just want to get mascara for your girlfriend? That's where you, the jury, have to determine. The part of the gang charges, the second part. The crime was committed to further the interests of the gang. There's absolutely no evidence of that in this case, ladies and gentlemen. That's just pure speculation, which is why I think it's going to be easy for you to determine as it relates to the gang charges that David Booker is not guilty of all the gang charges. The judge I told you earlier is going to speak to you about the defendant never needing to take the stand, and she's going to tell you he doesn't need to take the stand, and you can't ultimately hold it against him that he didn't take the stand. She's also going to give you the law as it relates to other crimes evidence. She's going to tell you before you can consider any other alleged acts, the death by receiving that my client pled to in Fulton, for the limited purposes stated, you must first determine whether it is more likely than not that the accused committed the other alleged act, not pled to them to get out of jail, as the expert told you sometimes happens, but that they actually committed the death by receiving stolen. Now, let's say he did that. Let's say he did, in fact, commit the death by receiving stolen property. I asked the person that was here, did you find any gun? There wasn't any gang talk about that. Yeah, well, we found 2 pistols, one with an extendo clip, and we found a bunch of gang stuff. No, there wasn't any talk about that related to the theft by receiving. That's just meant to poison you. You have the whole case. In regards to David Booker, you're left with 3 questions that you have to answer. 3 questions in regards to David Booker. Number 1, was he at the QT? Not whether his phone was pinging 30 minutes earlier in an area that covers a 2-mile radius of the QT. Not the digital DNA. Was David at the QT? That's the first question. If he is there, if David is at the QT, did he play any role in the shooting at the QT? Not purchasing insurance on a car where there are no text messages between him and anybody else about slider crimes. Did he play any role in the shooting at the QT? And there's absolutely no evidence. If you believe that he's one of the figures driving or running but not shooting. That's the second question. The third question is David a party to the crime of hijacking or aggravated assault or felony murder? Is David a party to the crime? Josiah Hughley has already admitted to being the shooter. So after you listen to Ms. Drake's argument about her client, who's already said he's the shooter, you've got to almost go immediately to party to the crime to determine if David and Miles Collins are parties to a crime. And you've got to make that determination with absolutely no text messages or social media indicating any sort of conspiracy. That's what you have to do it with. And based on the state's evidence, I contend you must say yes to all 3 of the questions in order to find David guilty. He was present. Let's assume that you think, well, he's not present, but wait a minute. The state's already told you they think he's present. So you can't come to a determination where you say, I don't think he was present, but I somehow think that he's guilty despite the fact that he wasn't present. The only way you're going to get to that is you're going to have to admit, I'm susceptible to the gang evidence. Because even the state is telling you they think he's there. So for you to say, I think he's guilty, but he's not even there, that's ridiculous. You have to say yes to all 3 questions. David was at the QT, David played a role, and David was a party to the crime of hijacking. But I contend you won't be able to say yes. Because you won't be able to say yes to all 3, because the evidence ultimately doesn't support it, it's going to be your duty. And that's the word that the judge is going to use, duty. It's going to be your duty to find David Booker not guilty of all charges. Thank you very much, ladies and gentlemen.
Thank you, Mr. Lewis. We've been going a little less than an hour. Does anybody need a comfort break? Okay. You do? Okay. Let's just take a 5-minute comfort break. Off the record.
We're ready.
Mr. Clegg.
All right, thank you, Judge. Good morning, ladies and gentlemen. I am somewhat of an anachronism. That means I'm old-fashioned, to put it bluntly. You will not see during the course of my closing argument a PowerPoint performance. You will not hear any sort of musical interlude. You will simply be listening to me talk for however long I talk. I will not, for the most part, be behind the podium. The podium is behind me, as you can see right now. I have put 2 documents on the podium to help refresh my memory as to 1 or 2 points, but for the most part, I will be speaking to you directly. Because I will be doing that, and let me be blunt, I know what I'm going to say, but the specific order of how it's going to come out would probably be different if I were to give this closing argument 10 different times. You would hear 10 different versions, but you will hear essentially the same thing. But invariably, when I sit down at the conclusion of the trial, I will think to myself, I neglected to mention this point, I neglected to mention another point, I neglected to mention or connect up a couple of facts, and I wanted the jury to be able to draw a conclusion. That's why I'm counting on you. You have had a difficult job. Jurors during a fairly lengthy trial, which this one has been, do not get an opportunity to speak themselves. They do not get an opportunity to ask questions of their own. They're simply required to listen and to absorb and to understand. During the course of this trial, periodically, I have glimpsed over at you. Primarily, I am focused on what is being elicited from the witness stand, but I have had a chance to watch you briefly and know that you have paid close attention, know that many of you have taken notes, and on behalf of Mr. Collins, I thank you for your diligence in that regard. Now understand how the system works. This is a criminal case, and as such, the state has to prove every material allegation of every specific count of the indictment beyond a reasonable doubt. The defense, Mr. Collins in my case, does not have to prove a thing. If he declines to present evidence, that cannot be used against him. What you have to do is listen to the state's evidence as it has been presented, and make a determination as to whether or not they have in fact proven their case, again, beyond a reasonable doubt. Now, as I told you in opening statement, ultimately, when you deliberate, you're going to have 45 different issues to resolve as to whether or not the state has proven their case. There are 15 counts of the indictment. There are 3 defendants. You will have to make 15 individual decisions as to each defendant. That will not be easy. And because of that, quite frankly, arguing a case where I am going to argue 15 different counts, some of which are considerably unique and different from one another, it is going to be difficult for me to argue to you in as perhaps a streamlined and effective manner as I might wish to do so. But be that as it may, I'm going to do my best to try to explain to you why it is that the state of Georgia has failed miserably in their attempt to prove Miles Collins guilty of any of the crimes charged in this case. Let's start with what ought to be the easiest charges for you, the gang charges. As to Mr. Collins, the gang charges really don't exist. You heard from a gang expert. The gang expert talked at length, primarily about Mr. Booker, somewhat about Mr. Yulee, and briefly about Mr. Collins. First off, what did he tell you about gangs in general? Gangs can either be highly regimented They can be loosely organized, or they can have no discernible structure at all. That was the testimony. How many people are in a gang? Who can say? I'm an expert, but I really don't know. I'm an expert, but I can't tell you about the local gangs. Who is the leader of those local gangs? I can't tell you where Mr. Collins might fall into a particular gang. I can't tell you what role he might have assumed in a gang. There has been no testimony whatsoever about when he became a member of a gang. Literally nothing was produced linking Mr. Collins at all to gang testimony in this case. He had a couple of tattoos. There were some flowers on one of his arms. I asked the expert, do those flowers have anything to do with gangs? Not that I know of. There was a spider sign, almost like a Spider-Man design on his neck. What does that tell us about the gang? Not much of anything. So you heard that the linking of Mr. Collins to a gang is minimal at best in this case. What was very interesting, however, was at some point during the course of this trial, there was a video shown, and it was only 7 or 8 seconds or so. It was a gentleman wearing a hat. I think it was a red hat. He had a pair of glasses on. He was performing some sort of song. Exactly what he was singing about or rapping about is unclear. That apparently, according to the gang expert, came from Mr. Collins' Instagram account. Was that Mr. Collins? It was not. The gang expert conceded. I have absolutely no idea who this is, but I can tell you that it is not Miles Collins. So in trying to convince you that Miles Collins is a member of a gang, the state of Georgia presents evidence of some individual, identity unknown, for a matter of seconds, 6 to 8 seconds, performing some sort of song and suggests that you should take that and decide, yes, in fact, that links Mr. Collins to a gang. That's preposterous on its face. Now think also about this. There are 10 gang counts. 5 of them are repeated, or all 10 of them, there's actually 2. They're repeated 5 times. I mean, there are 5 underlying charges: felony murder twice, aggravated assault, hijacking of a motor vehicle, and possession of a firearm during the commission of a crime. As to each of those counts, there are 2 corresponding gang charges. If you listen carefully, and I know you have, you know that the indictment alleges basically that all of those gang charges relate to the offenses that are charged, the substantive charges that are charged. They could have just said, here's the gang charge, done it 2 times and been done with it. But instead they have gone ahead and included it to each of the real charges that are pending in this particular case. Because let's be blunt, if you find Miles Collins not guilty of the underlying real charges, the gang charges are beside the point, okay? Make no doubt whatsoever. The gang charges only can be considered if you find him guilty of any of the underlying charges. If you don't, the gang charges go away. But implicit in the state's idea and the way they have indicted this case, and look at the indictment when you are deliberating, implicit in the way this case has been indicted is the idea of a contemplation by the individuals involved that the underlying offenses were contemplated to be committed during the commission of this offense. Okay? Those offenses are felony murder, ag assault, hijacking a motor vehicle, possession of a firearm during the commission of a crime. All 5 of those crimes require the use of a firearm. All 5 of those crimes allege the use of a firearm. Is that what was contemplated in this particular case? Mr. Melvin, in the course of his direct examination of Sergeant Harrison, basically elicited from him some testimony about his days back when he was a general detective, before he became a robbery detective, before he became a homicide detective. He asked him, are you familiar with something known as slider crimes? He said, yes, I am, and went on to describe it. I elicited further testimony about what exactly is a slider crime. And at this point, you folks have a pretty good idea what a slider crime is. It is a crime of opportunity. It is a crime of stealth. It is a non-confrontational offense. The idea is to find someone who has gotten out of their car for the purpose perhaps of putting air in their tires, perhaps for putting gasoline in their car, but who has left the car unoccupied. The car is in a position where it can be driven off by someone getting into the car. That is the whole idea of committing the offense, so that the victim and the perpetrator never come into contact with each other. There is no contemplation in that kind of offense for the use of a weapon. Now, in this case, obviously a weapon was involved, allegedly by Mr. Hewlett, okay? But in this case, you have to decide, was this something where it was contemplated that there would be a confrontation, that a gun would be exhibited, where a gun possibly could be fired, and a gun would be used? Or you have to decide whether or not this was simply going to be a stealth offense of trying to steal a car. If it is the latter, then the state has a real problem, because in each and every one of the gang counts, they have alleged that these were done for the purpose of trying to bring status to the gang and status essentially to themselves. Now think about that logically for a second. If the offenses were not contemplated, no one expected that the gun would be pulled, no one expected that the gun would be used, then how on earth could they have been contemplated in advance? But that's what we've got here. You've seen the video. You know what the video shows, do you not? The video shows that the Charger is sitting there, someone is putting air in the tires, Mr. Coleman. Mr. Coleman is out of the car. The video shows someone get out of the Mercedes. The video shows that individual who has gotten out of the Mercedes get into the driver's side door of the Charger. You know from watching the video, Mr. Coleman, the owner of the car, is on the passenger side. You know, realistically, from watching the video, Mr. Coleman cannot be observed by the person who has got in the car. Mr. Coleman at some point becomes aware of the fact that his car is being taken and responds. But that obviously is not the intention of what was supposed to have occurred. The offense was supposed to have been committed. The Charger was supposed to drive off, back away, go away, and no confrontation between the perp and the victim was ever supposed to have occurred. No handgun was contemplated. That makes common sense. You know it. You've heard the evidence. You have, more importantly, seen the evidence. Now, one of the questions that arose, factual questions that arose during the course of the trial, is when exactly is it that Mr. Coleman came to the realization that his car was being taken? Was it when his car was started? Had he left his car running? Or was it when the actual two cars collided with one another? By that, I mean the BMW and the Charger. I would submit again, and you've had an opportunity to see the video, that what happened was when the two cars hit each other, when the Charger was trying to back up and drive away, and wound up hitting the BMW, which just perchance happened to pull in front of it at the last second, that is when Mr. Coleman reacted. Okay? Again, that is contemplation that the car was to be stolen right then and there before Mr. Coleman had an opportunity to realize what was going to occur. Again, all 5 of the substantive charges in this case allege the use of a firearm. They contend that in advance of the offense, a firearm was contemplated. A firearm was going to be used. Are you satisfied with that under the circumstances that we have in this particular case? Because that's essentially what the state has to prove. What you've got instead is Mr. Coleman going ahead, reacting to someone trying to steal his car. He happens to have a gun of his own. He produces that handgun sometime during the course of the brief incident which transpires. If he had not produced the handgun, his handgun could not have been taken from him. That handgun ultimately winds up on the ground where he is having a dispute or a scuffle with the individual who had been in his car. We know that there had been, according to Detective Harrison, from his watching the video, that there had been some sort of scuffle inside the car. No shots were fired inside the car. You know that. Harrison said you can't hear the video, but at the same time there are victims there. There is only evidence of one shot. There is only evidence of one shell casing, and there is no evidence of any sort of damage in the interior of the Charger, which is consistent with a shot having been fired inside the car. Logically, what happens is that the person who is backing away in the Charger, trying to steal the car, all of a sudden becomes aware of the fact that he is being confronted by an individual with a gun. He is trying to get out of the car. Presume hypothetically, presume Mr. Hewley is that individual. That is the evidence you have heard. The state would argue, and I expect that they will, that Mr. Hewley, instead of just trying to get his ass out of Dodge, decides instead, I am going to stay here and get into a shootout with Mr. Coleman. Does that make sense? Who got out of the car first? Who's on the driver's side of the car? We know that's Mr. Hewley, right? Who's on the passenger side of the car? We know that's Mr. Coleman, right? Who comes out of the driver's side car first? That's Mr. Hewley, correct? Who follows out? Mr. Coleman. Now, during the course of the trial, you heard certain people offer their opinion that Mr. Hewley pulled Mr. Coleman out of the car. You can use, in the course of deliberating in this case, your common sense. You are expected to use your common sense. Realistically, is that plausible and is that believable? In this particular case, the evidence is no, it is not plausible and it is not believable. First off, we know Mr. Coleman is a tall guy. We have heard testimony from his mom. He was, according to her, 6'9". We know there's a center console in the car. That would make it more difficult for one person to pull the other person across the center console and out of the car. We have heard testimony elicited by Ms. Drake that Mr. Hewley was 5'8", 140 pounds, according to the warrant, when they sought to arrest him. So we've got a guy who's 6'8", 6'9", another guy who's 5'8", and the 5'8" guy who's bailed out of the car, who's trying to get away, is for some reason going ahead and pulling out the individual who is much stronger, and whether he's stronger or not, I don't know, but much taller, certainly, much bigger than he is. Again, is that plausible? Now, at that point, had Mr. Coleman produced the gun? We don't know for sure. We can't see inside the car. But logic tells us, yes, he had. Why do I say that? Here's why. First off, his holster is still in the car. It's on the passenger side of the car. That means he either got the gun out of the holster in the car or had the gun on his person when he was putting air in the tires. But at some point, he's got the gun in his possession when he gets out of the car as well. Another point, that Mr. Hewley pulled him intentionally out of the car with the intent to cause him injury, then do you really believe that he was able to do so with a gun in his hand? If you've got a gun in your hand, it basically prevents you from using that particular hand. So if the gun has been produced by Mr. Hewley before they get out of the car, that's pretty much going to require Mr. Hewley to have pulled out this guy who's a full foot taller than he is, pulled him out on his own using one hand. Again, 6'8", 6'9" individual across a center console. That, of course, did not happen. Use your common sense. Now you're thinking, that's all well and good, Mr. Clegg. What does that have to do with Miles Collins, David Booker, or the price of tea in China? Okay? The bottom line is, again, you've got to go back to what I spoke to before, what was contemplated. This was going to be a slider-type offense. Now, in the course of their case, the state introduced evidence of Mr. Collins's having previously entered a plea to 2 offenses in Rockdale County. Both of them involved what appeared to be slider-type offenses. You heard from the detective who testified in that regard. The first time, the evidence was pretty minimal. The detective said the car was stolen, the car was recovered 10 days later. Inside the car when it was recovered, there was a pizza box. The pizza box had an order placed in the name of Miles Collins. That order was made 8 days after the car was stolen. Okay? That's not much, is it? Okay? The second one perhaps had a tad more, but remember the particular facts of that case. Okay, a woman is putting gas in her car. Somebody gets in the car. The state alleges it's Mr. Collins, okay? Fair enough. The woman is having none of it. Not today. You ain't stealing my damn car today, or words to that effect. I don't recall her precise language, but she intervenes, she confronts, presumably Mr. Collins, and what does Mr. Collins do? Does he pull his gun and say, no, I'm taking your car? Or does he tuck his little tail between his legs and go about his business and run off? Is there any evidence during the course of that second incident, the only one that can realistically show that Mr. Collins was at the scene, which suggests that he had a gun and suggests that he was seeking a face-to-face confrontation with an individual? The evidence is no. And again, remember, every allegation in this particular case requires the use of a handgun. And when I say every allegation, the 5 actual crimes alleged, not the gang charges. So while they may shed some light, they don't shed much light as to whether or not he is guilty of the crimes alleged in this particular indictment. Now, jump ahead. Do you know that Miles Collins was there? And the answer is no, you don't. First off, you can see it's a Mercedes that drove away from the scene. You can see the point. I mean, there was a photograph taken by Mr. Waits, the gentleman from across the street. Mr. Waits got a good view of the car. There's no question that it's a Mercedes. We will concede that point. Okay? Is it the Mercedes that the police believe was used in the commission of the crime? You don't have a clue as to that, do you? Bottom line is there is no tag number seen leaving the scene. There is no tag number seen after the fact. All of the tag numbers from the flock cameras show something which occurred beforehand. None of them show the vehicle driving away. The detective would say, well, it appeared to be an out-of-state tag. We looked for a black Mercedes with an out-of-state tag. We didn't find one, therefore this must be the car. But think about that for a minute. They didn't find any vehicle, any black Mercedes after the fact, did they? Any evidence as to the tag number only came from something that occurred beforehand. And more importantly, is that the vehicle that Mr. Collins rented? I mean, think about this, folks. Mr. Collins in his statement says, yeah, I rented a Mercedes. Is there any evidence to show that the car he rented was the car used in the commission of this offense? And the answer is, no, there is not. You cannot, you should not engage in conjecture. You cannot engage in guessing. You cannot say, well, logically, yeah, this is probably the case. What the hell, he's a member of a gang. I'll echo Mr. Lewis here a little bit. He's a member of a gang. He must be guilty. He rented a car like that. We don't know whether it's the same car or not. Was the crime that appears to have been used in the commission of the crime. Therefore, he must be guilty. Come on. You know better than that. That's not sufficient. That doesn't come anywhere close. But again, the digital DNA evidence. Now, I agree with Mr. Lewis. The digital DNA is an attempt to make it sound that the mathematical precision for real DNA, 1 in 100 trillion or whatever the number was espoused, applies to phone records as well. No, it doesn't. First off, what phone records do you got? Phone records don't show us a whole lot, do they? Phone records show us that according to Mr. Collins's phone, at 11:23, he was somewhere south of the QuikTrip. Remember Detective Wilbanks, or Investigator Wilbanks from the DA's office? He had a number of exhibits. You can see where the cell phone towers are, and you can see where the area surrounding those cell phone towers are, where if an individual phone was in that area, it would bing off that tower. You saw one photograph, or not photograph, I guess, but exhibit like that regarding Mr. Collins's phone. It was not in the geographic area of the QuikTrip. Make no mistake, whether the others were or not, his phone was not in the geographic area of the QuikTrip. The only other evidence we get requires you to jump ahead to 12:51. At 12:51, Mr. Collins's phone is in Clarkston, or thereabouts. Now, Detective Harrison apparently doesn't know where Clarkston is, but we did hear from Detective Harrison the approximate distance from the QuikTrip on Peachtree Parkway down to 285. It is a number of miles. Realistically, do you believe that an individual could get from 1238, 1239 in Peachtree Corners at the QuikTrip to Clarkston in 12 and a half, 13 minutes? Because that's what the state is requiring you to believe if you're going to accept the digital DNA evidence. And what else do we know? In this particular case, the evidence shows that Miles Collins wasn't necessarily always in possession of his phone. There is testimony that Mr. Collins had two phones. One of those phones was used by Investigator Wilbanks to try to link him to the vicinity of the QuikTrip back on July 10th of 2022. Okay? But when the police went to his girlfriend's house, Jeremiah Pledger, on July the 21st, prior to Mr. Collins's arrest, which was on July 25th, lo and behold, they found that phone that was used in ultimately creating that exhibit. What does that tell you? There are times when Mr. Collins does not have his phone. Some of you younger folks may think to yourself, how can that possibly be? Why would an individual ever go somewhere without their phone? Some of you older folks may think to yourselves, no, that's not all that unusual. Who knows? Maybe you're attached to your phone. Maybe you're not. But the evidence in this case shows that at least prior to his arrest, Mr. Collins was not in possession of the phone that he was alleged to have had on July the 10th. The state will respond, but look at these maps. These phones are all together in the same geographic area, therefore you must convict. But think about this logically. We know that there was some testimony from the early morning hours of July the 9th. July the 9th was approximately 36 hours, I think Mr. Lewis correctly stated, before the events at the QuikTrip. Okay? At one point, there was an exhibit showing that David Booker's phone was in a particular area of southwest Atlanta, and there was evidence showing that Miles Collins's phone was in the same area of southwest Atlanta. One would infer, based on the state's contentions, that they might have been together at that time. But the evidence showed, no, that's not the case. Because what occurred at that time, when those two phones were binging off the same area, was that one person was calling the other. I suppose two people sitting in the front seat of a car, in lieu of talking to each other face to face, could decide to call each other on the phone, but that, of course, makes no sense. So even though two phones can be in the same geographic area, that doesn't necessarily mean that the two individuals are together. the state's own evidence is an example of that fact. The state will say, well, even though we can't prove the tag number was the vehicle rented to Mr. Collins, we can prove it through the Texaco video. You've seen a little bit of the Texaco video, have you not? Mr. Collins admits he was there. You can see a vehicle pull up on the far side of the gas pumps. That's pretty much all you can see. I will defer to you folks. You're younger than I. You probably have better eyesight than I do. But the bottom line is, looking at that car that the state will tell you is the car that was used in the commission of the offense at the QuikTrip, you have to ask yourself, can we realistically draw that conclusion? You can't see the tag. Harrison can see that, right? You really can't see much about the car at all. It does appear to be black. Can you tell it's a Mercedes? I don't believe you can. Again, that's your call. The prosecutor can't simply stand before you and say, I say this, therefore it is so. You have to be presented with evidence that allows you to draw your own conclusions. And in this particular case, you can't, based looking at that video. Now, were David Booker and Miles Collins together at that location 36 hours before the fact? Maybe they were. Does that mean that Miles Collins was present at the QuikTrip the following day and a half later, 36 hours later again? The answer is no, it does not. Realistically, what is it you got? I mean, the bottom line is there's a car that's been rented. It's a Mercedes. What else about the Mercedes? Let me jump ahead a little bit here. The Mercedes is recovered in Clayton County somewhere. Okay? We know that there is DNA evidence in this case. We know how sophisticated and adept DNA evidence has become. We know because certain DNA samples were taken off of a COVID mask. Okay? That DNA was subsequently connected to Josiah Hewitt. Okay? It was not connected to either Mr. Booker or to Mr. Collins. Okay? They were both excluded as donors to that particular mask. But where else could DNA have come from? First off, the state's theory is that Miles Collins was driving the car. You have heard from Detective Harrison, Sergeant Harrison, about the existence of something called touch DNA. If you touch an object, you may, by virtue of doing that act and that act alone, cause your DNA to wind up being on that object. If you're driving a car, what are you going to touch? You're going to touch the steering wheel, are you not? And during that time, Mr. Collins realistically is going to have to put his DNA on that steering wheel. Did you hear about that testimony from DNA taken off that steering wheel? They did collect it. They did try to find it. Matching up to Mr. Collins? The answer is no, you did not. Did you hear the evidence about blood transfer from the body of Mr. Coleman? Mr. Coleman has been shot. He is in close proximity to the individual who shot him. The individual ran into a car. Did you hear the testimony about how blood found inside the Mercedes from the person who got back in the car matched up to the DNA of Mr. Collins? Or Mr. Coleman, Of course not. You didn't hear that either. But again, the state says, trust us. It's okay. We know this is the car. We know these are the people involved. That's all you need to know. And gosh, look, they're in a gang. Although, for the life of us, when it comes to Mr. Collins, we really can't prove all that much, can we? But we'll show you. Look at this. Here's a guy singing for 6 to 8 seconds who is not Miles Collins. And that video is somehow supposed to convince you that he's in a gang, he's a bad person, and therefore he's guilty of this particular crime. What else don't you know? Who's the driver? The state has some evidence to show as to the other 2 defendants. Whether that's sufficient as to Mr. Booker is highly questionable. But as to the people who were there, who saw the offense, Can you tell us what the driver looked like? Nothing. Is he black? Don't know. Is he white? Don't know. Is he male? Don't know. Is he female? Don't know. Is he tall? Is he short? Can you describe any defining racial or personal characteristics? Does he have a mustache? Does he have a beard? Anything. Wear glasses? Anything at all. And there is no testimony in that regard, is there? Zero. Zilch. Okay? One of the interesting things about this trial was that Stanislav, and I'll butcher his last name, I don't recall it, Volkanov, the gentleman who drove the BMW, the gentleman whose car collided with the Charger as it was attempting to leave, was not called as a witness. You've seen the video, have you not? Who had a better view of the events as they transpired than him? Who was closer to the events in question as they occurred than him? But nonetheless, he's not called. Instead, you get a woman who's cowering behind a rental car, and I do not fault her for that. As well she should. Shots are fired, what the hell, I'm down. And a guy who's across the street. What else do you know about the scene? You know that the shot was not fired until the individuals were about 8 to 10, I think actually 10 to 15 feet, according to Sergeant Harrison. Why does that matter? That matters because if you believe the state's theory, Josiah Hewley pulled Bradley Coleman out of the car with the intention to shoot him. But they were both able to get 8 to 10 feet away from the car, and it was when Mr. Coleman was presenting his weapon that Mr. Hewley fired the shot. You have heard his statement. That is a guy who basically says, I didn't intend to do it. Doesn't even say he's the person who interjected the gun initially into the circumstance, but it was him or me. He made the decision. He will have to bear the consequences. But again, was that something that was contemplated by everybody in the car? Again, to consider that ultimately, you have to decide, was Mr. Collins in the car? Do you have that evidence? There is some evidence to show that he turned a car in. You heard from Ms. Pledger. Ms. Pledger said he was by himself. Mr. Melvin said, didn't you stand up before and say he was with Mr. Hewley? Well, let's go back even further. When she's first questioned back in July of 2022, does she say anything at all about Josiah Hewley when she's talking to the police? No. Name never comes up. Is she telling the truth? Obviously, who knows what she's doing in this particular case. But we do know from her testimony, she's basically, at the time after the events, seeing Mr. Collins on a regular basis. She does not see Mr. Collins in possession of any gun whatsoever. She does not notice anything out of the ordinary about Mr. Collins, and she does not notice, or nor did you find, or will you hear, any evidence of him bragging about what transpired on social media. In order to gain prestige, in order to maintain status for the particular crimes alleged in this indictment, you gotta let somebody know what you did. You gotta own up to what you did. To some extent, you almost have to brag about what you did. Is there any evidence to show that this gentleman seated over here did any of that after the fact? And the answer is no. But you know what? All of what I have said bows down before this. Mr. Lewis, in his closing, basically talked about the concepts of mere presence and mere association. Okay? If you're there, or you're associating with somebody who commits a crime, absent more, you're not guilty. Again, the state has the burden. I would submit to you that at some point during the course of this investigation, the state of Georgia concluded there are 3 people in the car. By process of elimination, we know who did what. We know what Josiah Hewley did. We know what David Booker did. He got out of the car under their theory. And we know that Miles Collins was the driver. Again, where is that evidence? Because Harrison, on cross-examination, conceded the windows are tinted to the Mercedes, you can't see in the car, you don't know how many occupants there were. In this case, presume hypothetically you decide, now what the hell, he was there. Talking about Mr. Collins. If he's not the driver, then you can't show that he has aided or abetted the commission of the crime. Bottom line, he didn't shoot the guy, we know that for sure. Mr. Coleman was not shot by Miles Collins. There is no evidence to show at any point he was ever in possession of a weapon. But even if he were there, and I am not conceding that point, but even if he were there, unless you can show he is the driver, you have absolutely no business convicting him of anything. Now, if you thought he was the driver, and you thought he knew they were going to steal a car, then quite frankly, he's guilty of attempting to or stealing a car. He ain't charged with that. For reasons that are clear perhaps only to the state, they have decided to instead not indict him for theft by taking of a motor vehicle, but instead indict these three individuals for the offense of hijacking a motor vehicle. Listen carefully to the definition of hijacking a motor vehicle. It requires the use of force and violence. The force and violence would be the gun. In this case, whoever is taking that motor vehicle, Mr. Hewley in this case, is trying to do so before Mr. Coleman realizes what's happening and is trying to get away before Mr. Coleman can react. Once Mr. Coleman reacts, after the two cars have collided with one another, Hewley is trying to bail out. The hijacking of a motor vehicle is over at that point. Any homicide that occurred is not pursuant or not part of a hijacking of a motor vehicle. One, because there is no such offense of a hijacking of a motor vehicle in this case, based on the facts we have. And secondly, because the offense has been abandoned at the conclusion of the offense when Mr. Coleman intervenes. Okay? But the bottom line is, do you know, or can you conclude based on that that homicide had any connection to the hijacking of a motor vehicle? And the answer is no. Now, secondly, how do you know? Presume hypothetically again. Yeah, Collins was in the car. What the hell? Do you know that he knew Hewley had a gun? Do you know that he knew what Hewley was going to do? Do you know that he was the one who was going to drive the car away from the scene? Again, you know none of that. You don't. Again, the state is asking you, to engage in conjecture. This must be what happened. Plausibly, this is what happened. Now, that doesn't cut it. This is a court of law, folks. The case is based on evidence. Evidence has to be produced from the witness stand. If the state of Georgia cannot produce evidence answering specific questions, then you are not authorized to convict. And until and unless they do so, you should not, under any circumstances, return a verdict of guilty. Now, what about this question? That's an aggravated assault. The aggravated assault results in the death of Mr. Coleman. Is that a homicide? Seems like it. Is that a specific homicide? That will ultimately be left to you folks as jurors to decide. Okay? But at that point, what is the involvement of Miles Coleman? Again, presuming you think he's in the car. What is his involvement at that juncture? Because there had been two intervening acts from the attempt to steal the car. The collision with Mr. Volkanoff's car and the production of the firearm by Mr. Coleman. Okay? And at that point, it is two people who have guns, who are in position to shoot each other, and one person decides to shoot the other. That is a homicide. It is a homicide under any circumstances that has absolutely nothing to do with the gentleman who is seated right here. Whether he was in the car whether he was in the car or not, whether he was driving or not. The homicide is totally unrelated to anything Miles Collins has done. You will hear a jury charge basically telling you an individual can be convicted of murder, felony murder, if a co-defendant shoots and kills somebody. But I would submit to you, ladies and gentlemen, that that contemplates a situation such as this. Two people decide to go rob a convenience store. One person's the getaway driver, the other person says, I got a gun, I'm going in, I'm confronting the victim, and I'm gonna take the money. Things go south during the course of the robbery. The convenience store clerk winds up getting shot and killed. Everyone concedes that the getaway driver knew about the fact that there was a gun. Everyone concedes that the getaway driver was aware of the fact that that gun was going to be exhibited, and everyone concedes that realistically that is something that could happen when you use a gun. But you gotta know a gun is being used. You can say, of course he knew. Why? You gotta have proof as to why it is that you believe that. Again, conjecture isn't good enough. You can't just go ahead and decide that must have been what was going to happen. You've got to decide, has the state of Georgia actually produced proof to satisfy us beyond a reasonable doubt of my client's guilty? Again, Miles Collins is who I represent. I don't represent the other two gentlemen. Again, I have no desire to assist in their prosecution. To some extent, during the course of my argument and presentation of evidence, I may have helped them out. Whether or not, I don't know. But the bottom line is, I represent Mr. Miles Collins. And when you go into that jury room, you've got to decide amongst yourselves, what exactly can they prove? What exactly did he do? And what exactly is it that we simply don't know? If ultimately you get to the point where you decide, I simply don't know, then your duty is to find Miles Collins not guilty of each and every one of the charges. Again, the 5 real charges in the case, not the gang charges, all involve the use of a firearm. No matter what you believe about Miles Collins, there is no evidence to show that he knew anyone had a gun, that he had a gun, or in fact that he was actually in the car at the scene. And even if he were, as I said, even if he were, how is it he has aided and abetted in the commission of those 5 crimes? That's what you gotta decide, folks. Not an easy question. Is it a tragedy that Mr. Coleman is deceased? Damn right it is. The guy's minding his own business, trying to put some air in his tires on a Sunday afternoon at 12:38, 12:39 in Peachtree Corner. This should never have happened, but for fortuitous circumstances, it never would have. But to take from that tragedy and decide that my client, Miles Collins, seated here before you here today, is guilty of the crimes that he is charged with, would be pure and simple a travesty. Consider what I have said. Listen to Ms. Drake, listen to Mr. Melvin, listen to the entirety, and listen to one another. I submit to you, ladies and gentlemen, that when you ultimately deliberate as to the fate of Miles Collins, my client, you will have no option other than to return a verdict which reflects the truth, a verdict of not guilty as to each and every charge of the indictment. I thank you for your attention.
Thank you, Mr. Clegg. Ladies and gentlemen, I think we'll go ahead and take our lunch break now. I'd like to start back at 1:30.
Do I have a grand jury bailiff that I need to see?
No, I thought you were from the grand jury. Do you have to eat in the conference room? Deliberation, okay. Ladies and gentlemen, I hope you enjoyed your lunch. Our jury lunchroom is being renovated, and they started today. So apologize for inconvenience, but I hope you enjoyed your lunch. I think we are with Ms. Drake.
Yes, ma'am, thank you. Good afternoon, ladies and gentlemen. Again, my name is Tracy Drake, and I have the privilege of representing Josiah Cooley in this matter. Just a couple of things. I always do this. I wanted to thank all of the people that make this trial possible. Our bailiffs, Madam Court Reporter, both of the Johns here at the table, Mr. Melvin and Mr. Williams. It's always nice to fight with people that are so pleasant, so I always appreciate that. And to the co-defendants attorneys in this case, of course the deputies, they help keep us in line, and of course the court itself. But most importantly, I want to thank you for the time and the attention that you've paid to this matter. Obviously, it is a very important case. It's very important not only for the family and friends of Mr. Coleman, but it's also very important to these three young men sitting here at the table before you. So as I did in my opening, I like to go through the law and how it applies to this case. The facts of this case are not greatly in dispute. There are some interpretations that may differ from person to person, but the basic facts of this case are the same. Now, I know that my co-counsels, for lack of a better word, have already gone over a little bit of the law, and a lot of their arguments I'm going to try not to duplicate, but since we do represent each of these young men separately and independently, I think it is possible in my representation of Josiah to maybe reiterate some of the same arguments you might have heard. But let's start off with talking about some of the law that's going to be very important in this case. And this is in no way everything that the judge is going to tell you. But these are some of the basic laws that you need to understand, and also some of the laws that are very specific to this particular indictment. First off is the presumption of innocence. Now, we've talked about that. What is the presumption of innocence? As this trial started, and even as they sit here today, these young men are presumed to be innocent until they're proven guilty. What's very important is that no person shall be convicted of any crime unless and until each element of that offense has been proved beyond a reasonable doubt. That's going to be important when we discuss the indictment in this case, how it was indicted, and why it was indicted the way it was. The burden of proof rests upon the state to prove every material allegation in the indictment and every essential element beyond a reasonable doubt. There is no burden whatsoever upon the defendant. We're going to talk about that a little bit more going down. The burden never shifts to the defense to prove innocence. Most importantly, especially in this particular set of facts, is that when a defense is raised by the evidence, the state also has the burden of proof to disprove that or negate it beyond a reasonable doubt. So what is the burden of proof? It's kind of common sense. I know we've all heard that term, but sometimes it needs to be defined. A burden of proof means that the state has the burden to prove their case beyond a reasonable doubt. Now, what is a reasonable doubt? It is a doubt of a fair-minded, impartial juror honestly seeking the truth. It's a doubt based upon common sense and reason. It is a doubt for which you can turn to the person beside you and say, I have a doubt because of A. It's not a vague or an arbitrary doubt, and it can come from a consideration of the evidence, a lack of evidence, which there is a lack of evidence, and we'll talk about that in a minute, or a conflict in the evidence. If all of the facts in this case, and after you consider the law, your minds are wavering, you're unsure, you're back there going, it could be this, but it could be that, I'm just not sure, then that is a doubt. And your oath requires you that you are not authorized to convict the defendant in this particular case. And when I refer to defendant, I am normally just referring to Mr. Hewley unless I state otherwise. Now, this up here, the judge is going to give you a charge, and it's going to have some extra words in here. I meant to go back and add them, but I fell asleep last night. Got too excited after the Kansas City game. To authorize a conviction, the proved facts, the judge is going to add in some language. To authorize a conviction based upon circumstantial evidence, and she's going to define that for you. The proved facts must not only be consistent with the theory of guilt, but also exclude every other reasonable theory other than the guilt of the accused. The state is not going to be able to do this. Circumstantial evidence, direct evidence, a combination of that, they are not going to be able to disprove what their own evidence proved is another theory of this case. That is not felony murder, it's not ag assault, it's not hijacking. Grave suspicion. This is very important when considering a case, because obviously there's got to be a little something there to make you think, oh, well, something happened. But a grave suspicion that mainly places upon the defendant a speculation or a suspicion of the crimes charged is not sufficient to authorize a conviction. A single witness being corroborated. The testimony of a single witness, if believed, is sufficient to establish a fact. Generally, there's no legal requirement that you have to have 2, 3, 4, 5 witnesses. One witness can create a fact. And in this case, the state's witnesses are going to be very consistent, and they're all consistent with Josiah. Mistake of fact. I don't think there's really a mistake of fact in this particular case, but I expect the state to argue this. A person cannot be found guilty of a crime if they mistook something for being true and it turned out not to be true. If what they thought was true and it would justify what they did, that is a mistake of fact, and you can't commit them. The state is going to argue mistake of fact is not a defense in this case because of Josiah. It's Josiah's fault. He made all of this happen. However, first off, there is no mistake of fact. The best the state can argue is that, oh, there's no way Mr. Coleman would have shot him. He wasn't going to shoot him. We really don't know. We do know that he had a gun. We do know that he was physically fighting with Josiah, not letting him leave the car. That was not brought on by Josiah in this case. He was trying to remove himself from the situation. Again, the defendant not testifying, you cannot consider that for or against because, of course, we do not have the burden of proof in this case. Intent. I know that some of the other attorneys have already addressed intent. Intent is very, very important. You have to prove intent on every single crime. What was the intention of the individuals? And that has to be proved to you beyond a reasonable doubt as well. Knowledge. Knowledge is important in this case, and I believe you heard both Mr. Lewis and Mr. Clegg reference this. But in this particular case, knowledge is important for Josiah because there was no knowledge that this was going to be anything other than a slider crop. No idea that a gun was going to be pulled. No idea that he was going to end up shooting someone. So the charges. And I'm going to go about them a little bit different. They're not really indicted in chronological order. So I want to go back and kind of start chronologically what happened. And if you will notice, and as you've been told before, there's double the charges for gang than what actually occurred in this particular case. But we're going to go through all of those. So I would like to start with hijacking a motor vehicle. That is in count 10 of this indictment. The indictment says that on July the 10th, did attempt to obtain a Dodge Charger from the immediate presence of Bradley Coleman by force and violence while in the possession of a gun, and the attempt is enough, and the attempt was pulled up beside Bradley Coleman, there was actually a car in between them, and entered the vehicle. I fully expect the state to get up and say, all we have to do is prove attempt. That's all we have to prove. That is not exactly true. They do have to prove an attempt of hijacking. At best, the evidence in this case is an attempt for theft by taking motor vehicle or entering an auto with intent to commit a theft. But they didn't charge either of these defendants with that. Why? They overcharged. They wanted to go to hijacking. So let's look at what the court is going to instruct you on hijacking. First, let's go here. So what we know, while in possession of a gun, we're going to talk a little bit about what possession of a gun means. It's not simply having a gun somewhere on your person when you're talking about hijacking. No gun was ever presented. No gun was ever referenced. There was no evidence that Josiah went, look dude, I got a gun in my pocket. I want your car. No evidence to that. A criminal attempt to commit a hijacking, which encompasses all of the elements of hijacking, would be me pulling up to you and you're in the driver's seat and I've got a gun saying, give me your car. But you drive off. That's an attempt. That has a gun, that has force or threat of violence to it. That's an attempt. I didn't get the car. That is not the case here. I didn't hit him. I told him I'm out. I'm getting out. And there's a lot of other witnesses that support this, and we're going to get to that. No force was ever obtained. The state's evidence is that Josiah never even hit him. So there's zero force. Zero force. The attempt has to be for the crime that is charged with this, which is hijacking. It's not entering an auto, and it's not theft by taking. So when the state in their closing gets up and argues that, remember, it has to be an attempt to commit the crime that they're charged with in this particular case. The use of an offensive weapon during a hijacking must either precede or be contemporaneous with and not subsequent to the taking. So what do we know here from the state's evidence? No gun, other than the victim's gun, was ever presented at any time until after both individuals were out of the car. There was no indication that getting into the car, a gun was out. It has to be the use of. Not that I have it in my pocket, not that I have it in my waistband. No evidence that Mr. Coleman saw a gun. The use of the offensive weapon. Because that's what makes hijacking different from the other charges. And it cannot be subsequent to the taking. That's going to be important when you look at obtain. Obtain a Dodge Charger. Obtain means to gain or attain possession. So what does that mean? Therefore, the offense of hijacking a motor vehicle, assuming that you've had a gun, assuming you've used the gun, assuming there's been a threat of force or violence, which there's not, but obtaining is concluded when possession of the motor vehicle is attained. So in this particular case, Josiah gets into the car, presumably his hands are on the steering wheel. We don't know if the car was running or if Josiah had to hit the button to cut it on because Mr. Coleman was outside. He was in possession of that car. The car moved. Whose control was the car under? At that point, it was under the control of Josiah. So that was already over. That event had concluded. The crime is not hijacking because of no gun, no presentation of gun, no force, no threats of force. I'm going to kill you, I'm going to shoot you, nothing like that. Then we start on the gang charges. So, while being a member or associated, they said in their indictment, and, they used an and, but it's and or, while being a member or associated with a criminal street gang. This is going to be very important when we talk about Officer Post's testimony. The Bloods. Now you heard in the opening that my client is sex, money, murder. They have in the indictment Bloods. Conducted and participated in criminal gang activity, which you did hear testimony that hijacking a motor vehicle is normally associated with criminal gang activity by hijacking a motor vehicle, which we clearly do not have in this case. We might have something else, but the state decided not to charge them with that. The state charged Josiah with hijacking a motor vehicle. So simply based upon the elements, you cannot return a verdict of guilty because we do not have a hijacking. Second gang charge. Again, very important. While being associated or a member of the criminal street gang, the Bloods, they specified it in the indictment. You're going to have that back there with you. Criminal gang activity, hijacking a motor vehicle. So we stop right there, actually, because there's not a hijacking a motor vehicle, with the intent to maintain and increase his status and position. Again, no testimony whatsoever about status, what level he was on, nothing that anyone knew about this. And is it really going to increase your status if you basically wuss out and freak out and shoot somebody? Is that really going to increase your status? You didn't even succeed in the slider crime, but it's not a hijacking. So let's talk about Detective Post and all this gang evidence. So there's no intent to show that there was any plan or anything like that going on in Josiah's mind that, oh, I'm going to go do this because this is going to make me a real badass. Nothing about that. So we know that clothes are associated with gang members. No evidence of clothes. Zero. Zero evidence of clothes taken from Josiah's house that they could even argue ties him to a gang. Now, the state's going to get up and say, well, he sent this big long thing on sex, money, murder. That was after the fact, and we don't know who this person was that he was texting with. We don't know who the phone calls were before that. We don't know if somebody asked for that. He might have been talking to a gang member, saying, hey, I need the whole pledge. Can you find that from me? And he finds it and sends it. We just don't know. That, in and of itself, does not make him a gang member. One tattoo, Detective Post said, it's supposed to be a dollar sign, but it kind of looks like a 5. And gang members oftentimes have a 5. If you look at the picture, where is that tattoo? It's here, on this bone. Maybe the tattoo artist wasn't great, but it's on a bone. It's a little bit more difficult to have nice curves and stuff when you're tattooing onto a bone. And the 12 tattoo on the middle finger. Again, Detective Post agreed. A lot of young black men are not fond of the police, especially in this day and age. A lot of people in general just don't like police. Does that make him a gang member? No. Just means you may not like the police. We don't know when either of those tattoos were gotten by Josiah. Was it when he was younger? Was it a month before? We don't know. Nothing at all about that. The other tattoos, even though they said, well, maybe it could be like the 424 could stand for death before dishonor, but it doesn't have to. The one about the loyalty, that's not really gang specific. So we just have the one that's on the bone, and we have the one where Josiah does not like the police. Here's a big one. No social media. None at all. So if he's trying to increase his status in the gang, he's doing a very terrible job of it because he has no Instagram. There's nothing on Facebook. There's nothing. Not a single picture that was introduced has Josiah doing anything with the gang. Even if you believe, and the evidence is questionable, as you've heard from my other two co-counsels, even if you believe, let's just say for the sake of argument, that they're in a gang, and let's just say they are the Bloods. How is someone that is not associated with the Bloods going to increase his status in the Bloods when he's part of sex, money, murder? They also introduced other crimes. When the judge reads you the charge in here, the commission of crimes, the attempt to commit crimes, or the convictions of crimes can be introduced into evidence. Nothing like that was introduced for Josiah. What do we have? We have one first offender. It's marked clearly first offender. It is not a conviction. And I know that everyone looked at this, and I believe it was Detective Harrison. It could have been Detective Post, y'all will recall. But one of those two witnesses said, yeah, I have heard about people just entering the plea to hopefully get out of jail sooner rather than later. The incident date on here and the plea date is several months separating them. He got credit from the incident date to present, which indicates that he was in custody. And let's look at what he entered a plea to. Fleeing and attempting to elude. I don't like the cops. I'm not going to stop for them. I messed up trying to steal this car. I'm trying to leave. That's his general MO. So, fleeing and attempting to elude, theft by receiving stolen property, and that he knew or should have known, and they have it marked as a misdemeanor on the indictment, possession of a firearm. This is the one where it wasn't on him, it was in the seat. Remember, one of the other officers said, if a car wrecks, I don't usually charge anybody because there's no telling where the gun started. Did it slide out? Was it under the seat in the front, slid to the back? Nothing about that. Misdemeanor obstruction and driving without a valid license. That is it. The other crimes that they introduced evidence of, they really didn't introduce evidence if you think about it. Many of the fleeing, because the only people they put up were the officers who said this car was in the area or was suspected in some car thefts. Okay. No evidence about the actual car thefts. No evidence that Josiah was even there. What, if anything, he did or did not do. We just know that that's why they were wanting to pull that car over to start with. And again, we don't have any conviction of that. Nothing. No hijackings, no aggravated assaults, nothing like that. Basically, we have a young kid who gets scared and tries to run. That's what they have for their other crimes. Detective Post also told you the blood started in LA, then in New York at Rikers Island, which is a very rough place to be. It became protection to be in a gang. And that's pretty much true. I believe this is the correct acronym, United Blood Nation. They started that. But the very last question I asked Detective Post before I sit down, isn't it true that sex, money, and murder is no longer under the UBN? That they are a separate and distinct gang in and of themselves? The answer was yes. He did try to say, oh, well, they're associated because they were. That was in the past. We're talking about the present. So even if you believe that he is sex, money, murder, that's not what all these gang charges accuse him of. They accuse him of being associated with the Bloods and trying to raise his status in that gang, in the Bloods. That makes no sense. If you're trying to raise your status, you're going to do it in your gang, the independent gang, not this other one. We did talk a little bit about false claiming because Josiah did say at one point I false claimed. Detective Post said that is, that's common. Young juveniles false claim. But if they do that, it's very, very serious. They could be killed. Well, we don't have any evidence of how old Josiah was when he false claimed. Was he the same age when he got the tattoo on his eye? If you think that that's a gang tattoo. Who did he false claim to? Was he 14, 15, and he false claimed the gang to his little buddies in 8th grade? Is that what that was? Are those 8th graders going to kill him? He even admitted that sometimes people false claim and nothing happens to them. No social media. That is the big thing. You'll notice that the state tried to introduce a lot of social media to show gang, but nothing at all on Josiah. So now we're starting to work back up. We have count 7, felony murder. There is going to be a different charge that you can consider, but I'm not going to address that right now because we never had a hijacking to start with. And count 7 in the indictment is specific to the hijacking. Count 7 is that Josiah committed the offense of murder when he caused the death of Bradley Coleman, irrespective of malice, while in the commission of the felony of hijacking a motor vehicle by attempting to take a vehicle belonging to Bradley Coleman by force while in the possession of a firearm. That is the language in the indictment. We already know that there wasn't any force, and we already know that possession of a firearm means that the firearm is used, it's branded, it's somehow integral to the force component of hijacking a motor vehicle. So on this particular felony murder count, the evidence suggests that it should be a straight not guilty because the hijacking itself never took place. And again, loading you up here with the gang charges, like Mr. Lewis and Mr. Clegg said, we can't really concentrate on these 5 because we've got double of the gang charges. Because, let's face it, you hear gang, I don't care who you are. You think a certain way about somebody. That's just human nature. So let's just have 10 gang charges, and especially when the judge has to read 10 gang charges, the average person is like, oh my God, they're just a piece of crap. They're just a young thug. You can't let the number of charges and the overcharging convolute what the evidence is in this case. And again, these are specific to felony murder based upon hijacking, and they involve the Bloods. But let's look a little bit more about what felony murder is. Just because the death occurs at the same time that something happens, of course the death did not occur at the same time as Josiah got into the car, or even a little bit thereafter. There were so many intervening things that happened. That's not necessarily in and of itself means that there is a felony murder. So now we're going to go back up to count 1. Count 1 is felony murder, which has caused the death while in the commission of a felony, aggravated assault, by shooting. Now, I know you're sitting there going, well, that seems pretty straightforward, but we have to break down what the law is in regards to these particular charges. Causing the death of another by committing a felony, which aggravated assault is a felony. Again, just because there was a death, just because there was a felony, there may be additional factors that you have to consider. That is the connection part. Voluntary manslaughter. In considering the felony murder charges, and if collectively y'all decide, well, it was hijacking, you will have the option of voluntary manslaughter for both felony murder counts. However, the evidence in this case suggests that the only felony murder where a lesser should be considered would be voluntary manslaughter. In considering felony murder charges, you have to decide whether the defendant was sufficiently provoked and acted out of passion. If you find that to be the case, you cannot return a verdict of guilty on the felony murder, but you would be authorized to return a guilty verdict on voluntary manslaughter. This is very important. The state must prove beyond a reasonable doubt that the offense should not be reduced. This is a terrible, terrible situation. There's parents on this jury. I'm a parent. I cannot imagine what Mr. Coleman's parents are going through. I understand that. But, as I stated earlier, every homicide is not necessarily murder. Sudden passion. And I hope I get this right. I remember one time hearing that there are some basic instincts that every human has. Breathing, eating, sex, reproduction, however you want to say it, and to live. Basic innate instinct in every human being. For manslaughter, caused the death of another person under circumstances that would normally be murder, but it was because of a sudden, violent, and irresistible passion from serious provocation. And that was sufficient to excite such passion in a reasonable person. You're trying to remove yourself from the situation. You're getting hit. You know the person has a gun. You fall out of the car. The gun falls. You see that person reaching for the gun. The defendant in this particular case we're going to argue facts that mitigate the felony murder charge. Once this is raised, of course, the state has to disprove it. But I want to point out, the state, this is is the state's evidence we're talking about. This is the state's evidence. I do expect the state to try to get up and argue this, and let's look at why this is not applicable. A defendant is not justified in threatening or using force if he provokes the victim in this case and intends to use it as an excuse to harm. Zero evidence of that. You heard Josiah's statement. It wasn't supposed to go like that. If I had wanted to shoot him, I would have shot him in the car, or I could have shot him in the car. I was just trying to get away. I even told him, bro, I'm out. It's yours. I'm good. Is attempting to complete a felony, hijacking a motor vehicle, which is defined. We've already went over why it was not hijacking. But at any event, when the death occurred, that best case scenario for the state was complete. So there was no attempt going on. Is the initial aggressor? I do expect Mr. Melvin to say, well, he's definitely the initial aggressor. He got in the car, he was trying to take the car. However, what else did the state's evidence show? Unless he withdraws from the encounter and clearly communicates it to the other person, his intent to withdraw, and the other person continues or threatens to continue the use of unlawful force. Now, the court is not going to charge you on what levels of force you can use, but we would submit to you that when you're defending your property, if someone is leaving, you can't just threaten to shoot them. Provocation by words alone. So we did hear evidence that there was yelling going on outside of the vehicle. I can be calling you every name under the sun, calling you out of your name, whatever. Provocation alone is not enough. However, words coupled with menacing actions, even if they don't result in physical contact, may be enough to excite a sudden, violent, and irresistible passion in a reasonable person. Now, the defendant can't just act out of revenge, but if it creates such a state that you just react, which is the case here, then that's okay. And we do know that we have menacing actions, even though there's yelling, because the physical evidence completely corroborates the statement that you heard that Josiah gave to the police. And what is that physical evidence? We're going to hear Josiah's statement again in just 1 second. They fell out of the car, Mr. Coleman's gun dropped, and he was reaching for his gun. Now, how does the physical evidence support this? Because when he was shot in the top of the head at an angle as he would be reaching for his gun. That is how the physical evidence supports Josiah's statement. Not sure why this is not playing, but here we go.
Now it is.
Let's try it again. As I told you before, I am not the tech guru, though I have been pretty proud of myself. And I did check this beforehand, so it should work. Is there something you have to measure for sound?
No.
about that family that has been mourning the loss of their son and that little girl that's going to grow up. Here's the thing, as bad as it sucks that your daughter is going to have to deal with the fact, what you did and the consequences of what you did, and you have to deal with that, that's consequences that you brought on yourself. That guy didn't do anything to bring that on himself and to bring that on his family, and that is not right for his family and for his little girl. It's not right, man. So if nothing else, if you can just separate the two things, separate the consequences for you and think about his family, because regardless of how it affects you, the morally right thing to do, any human being that has any sort of a conscience, any sort of emotion, remorse, can feel that inside them. There has to be something inside of you where you feel bad for that family and for that little girl. It's not right, and they deserve that. And like Corporal Jorstad said, at this point, the thing for you to do is to be a man, to accept your consequences and accept your fate, because they're coming down the tracks whether you like it or not. So the best thing that you can do right now, the right thing that you can do right now, Josiah, is do right by that family. They deserve it. Think about them. If you can't get past how it affects you, think about them.
So, you have a daughter. Mr. Coleman has a daughter. Think about his family. Think about his daughter. You're going to suffer the consequences, but give this family some closure. If you have any remorse at all, you will give this family closure. That is when Josiah told the officers what happened. He thinks about what they said. He drops his head. He puts his head in his hands.
About that little girl.
Alright, so I don't know, it's just like I got in the car and when I seen him get up, I tried to get out the car. But by the time when I got in the car, I seen his gun on the passenger seat. So of course, my first instinct is I'm thinking he's gonna go for his gun, but he started grabbing me and hitting me. I didn't hit him back not one time. My whole thing was I was trying to get out the car. I was trying to leave it alone. I even told him during the middle of the incident, I'm telling him out my mouth, I put this on my child, my grandma's life, on everything I love. I'm telling him, I say, okay, get off of me. I'm finna get out your car. I'm like, get off of me. I'm finna get out your car. You got it. My bad. He's still just doing the most. It's just like, I don't know how he pushed me out the car. When he pushed me out the car, we fell. He tried to grab his gun, like I knew he was reaching for, like, when his gun went for, I knew he was going for, like, he was going for his gun. So I'm like, okay, when he grabbed his gun, he's finna shoot me. Even though I told him, like, I know he's finna shoot me. And then, it was how it happened, like.
So what happened at that point? You dropped the gun on the ground.
The gun was, I think the gun was in his hand when we failed to drop.
Okay.
Inside the car.
When you got out of the car, what happened at that point?
The gun was on the floor when we got out of the car.
Which gun?
His gun.
Where was your gun?
In my pants.
Okay.
I never pulled it out. That's the whole point. I could have pulled the gun out inside the car and shot him or something like that. I wasn't trying to touch that, man. I wasn't trying to do nothing like that.
I know that. I believe you. I mean, the video, I believe you. You're telling the truth about that. The video confirms it. But I'm just, so his gun was on the floor.
At what point did you put it in your hand?
I want to stop right there. The judge is going to instruct you that what these officers are saying during this are not evidence. However, what Harrison said there, he also said it on the stand. I know, I saw the struggle. There was an altercation in the car. He talked about that on the stand.
Gun? Yeah. When I was leaving the scene or something.
So did you shot him with your gun and then you took his gun after that? Is that right?
It's like, yeah.
So once he pushed you out of the car, his gun was on the floor of the car at that point, but y'all. Okay, I'm sorry.
It was never on the floor.
Okay.
It was in the passenger seat the whole time. He
Gotcha.
had it on the passenger seat the whole time. He was in the passenger seat while he was pumping out. So I seen it. I didn't even touch it. But when he got up, he jumped in the car. He started hitting me, beating me up. And I'm telling him, like, you know, I'm leaving. I'm leaving. You got it, bro. I'm running wrong. I was trying to do the right thing at the time. Like, I was trying to leave it alone.
Let's talk a little bit about Josiah's statement and what the other state evidence was. There was a witness who hid, he pulled him out of the car. We know from the autopsy report that Mr. Coleman was 203 pounds. His mom said he was 6'9". I believe she said 6'5" to 6'9". We know that Josiah is 5'8" and 140. Sometimes when you recall an event, you're recalling the whole event. You're recalling the event knowing that one of the individuals has been shot. Does that maybe take on whether it was a push or a pull? Whenever someone has a hold of your arm and is trying to hold on to you and get you out of the car, and you're pulling like this to get your arm away, could that look like trying to pull that other person? Arguably, yes. But it's also Josiah trying to get away. Physically, this is not reasonable and it's not possible. Not only pulling someone that big with that much weight differential, he almost weighs 50% more than Josiah. He's basically having to drag him over a center console. That just does not make sense. Detective Harrison corroborated the statement. I watched that video, what do you say, 1,000 times? 10,000 times? I don't know, 1,000 times? You can see an altercation. You can't see if anybody had a gun when they got out, but you can see that there is an altercation. The witness across the street corroborates that. There was yelling and screaming. We don't know who or what was said. There was screaming, and then someone pulled, a gun out. No gun visible before then. Excuse me, one moment. The witness across the street said that until that gun was pulled out, he did not see one. And why was he not able to see the one the victim had? Because it had fallen. When they finally got out of the car, it fell, and Mr. Coleman had reached down. Now, I do expect the state to make a big deal about, he posted a picture of his gun, and he sold it, and he lied to the police. You have to keep in mind, and no offense to my client, but at this time, back in 2022, he had just turned 20. Basically still a baby. And no offense to the men, but 19, 20, 21-year-old men, young men, they're still babies. They don't always make the greatest decisions. And he wanted to remove himself from the situation. I mean, he's freaking, I would be freaking. I go there just to do a quick little slider crime, and I end up shooting someone that I was trying to get away from. I certainly did not want to kill him. I want that removed. But I'm not going to bring another soul into this. I'll just tell the cops I got rid of the gun. That does not negate Josiah's statement about what happened and all the corroborating evidence. So, Detective Harrison, slider crime, non-confrontational, weapon is usually not involved because it's just a game of crime based upon stealth and convenience, a crime of opportunity. Detective Harrison, Coleman gets in the car after it moved. Both doors are open. There's an altercation in the car. Could not determine, you could tell I was working on this late, if either had a gun when exiting the vehicle. Josiah pulled his gun out of the holster. Now, why is that important? That goes to show you that Josiah never had a gun displayed or used it in the car. Because when Mr. Coleman got in the car, they started fighting. So, does it make sense that Josiah would then take the gun, put it back into his holster so tight that when he pulled it out, outside of the car, the holster came with it and failed? The distance from the car to, unfortunately, where Mr. Coleman was found, there is a distance. There's no blood in between there to show that there had been anything in the car. No blood in the car, no gunshot residue, no casings, nothing like that. And again, same thing. You know, they're bad gangbangers. Even though he's not a blood, and even though it's not felony murder, we're going to add those on there. Aggravated assault. Make an assault with a deadly weapon by shooting. But in this particular case, you have to ask the why. You still have to have intent on something like this. Sudden passion is why he pulled the gun. The court is going to instruct you that for aggravated assault, the state must prove that the defendant assaulted another person with a deadly weapon. And of course, the gun's a deadly weapon. That would be defined for you as well, but we all know that it is. To prove assault, the state does not have to prove that the other person was actually injured. However, the state must prove that the defendant committed an act that placed the person in reasonable apprehension of fear or immediately receiving a violent injury. There was no indication that Mr. Coleman was scared. In fact, based upon the physical evidence and how fast everything transpired, he never even saw the gun because of where he was shot. And again, the gang charges. On the manslaughter, with the aggravated assault, that takes the gang charges out. But let's talk about intent even outside of that. There was never an intent for aggravated assault. Ever. Never an intention for a shooting. And then we go back down all the way to the bottom on count 13. Did have a firearm during the commission of a felony, and it's very important the felony that they chose. They chose felony murder. So the hijacking felony murder, we've already talked about, it wasn't a hijacking. It wasn't a criminal attempt to commit a hijacking. It might have been a different crime. It might have been a different attempt to commit a different crime. That's not the way the state chose to indict it. And they are bound by their indictment. Felony murder and the aggravated assault felony murder is really manslaughter. And again, you've got the the charges that go along with that. So what do we have? We have a young man that was scared. He told them in the interview. He was remorseful. That's when he told them what happened. You've got to have some remorse. Give this family closure. You've got a daughter. Think about Coleman's daughter. His statement is consistent with the state's witnesses and cannot be disproven. It has to be beyond a reasonable doubt. If you're kind of like this, that is a doubt of the law, and you have to acquit. State did not accuse the right crime in this case. This is not a hijacking. Theft by taking motor vehicle, entering auto, probably could have been those, but they just overcharged it. Added the gang to create a prejudice, which we all do. I mean, I'm a criminal defense attorney, and I hear gang, and I'm like, oh, Lord, roll my eyes. That's just normal. And, as Mr. Clegg said, I believe it was, it's because the state knows that there's problems with this case, and hoping that you're going to convict Josiah because he's a terrible gang member. And they just suck as human beings. You know, the gang talking about the 65% of all crimes. All crimes. So that's child molestation, rape, shoplifting, blah, 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 blah. They've been in existence for over 20 years, this organization, and they spend all this money on research, but not any research about what can we do about it. The state mislabeled the gang, said it was Bloods. Sex, Money, and Murder, according to Detective Post, is its own independent gang. So what are we missing in this case? Intent for everything except for a slaughter crime, which we know is normally not done with violence, according to Harrison, and we know that there was no force or use of a gun. What about the witness? Remember the young lady, I believe her first name was Paige, who said that she ducked down behind the car because somebody behind her screamed, "They got a gun," or maybe the quote was, "He got a gun." One of those two, they got a gun. Where is that person? Did they talk to that person? We have tons of other witnesses. They talked to witnesses, and then there were what, at least 3 or 4 that not only they talked to, they had them write statements. Why would you have somebody write a statement if they didn't have anything pertinent to say about what occurred? Don't let the state get up and say, well, the defense could have called those people. No, it is the state's burden. That is what our justice system is about. And the main witness, the guy with the unobstructed view in the BMW, he was literally up against that vehicle. Where is he? We know he gave a description of the tag. He may not have gotten all the tag numbers, but where is he? I would submit he's not here because, again, it's consistent with what Josiah said happened. The holster testing, the holster that was found inside of the vehicle. We have heard a little bit about touch DNA, fingerprints. We know that all of that was obtained from Josiah. But you know what? You know why there's no holster evidence? Did you hear one witness say, we sent it out to the lab, we couldn't get anything off of it? No. They didn't even try. In Josiah's past, no evidence of convictions of actually he himself stealing a car or using a weapon to steal a car. There's no evidence, contrary to what Josiah and the other witnesses said happened. The state cannot disprove to you that he reacted out of a sudden passion, did not intend to commit an ag assault, but based upon the innate will to live, survival instinct that everyone has, he reacted. So I know whenever you get chosen for a jury, a lot of you let out a deep sigh, especially on this case when you knew how long it was going to be, and I don't blame you. But what is the duty of a juror? The juror needs to review all the details. I think in my opening, I asked you to pay attention to details. Because if you look at this from a big picture, you're like, oh, it seems pretty open and shut. But it's not when you start looking at the details and the law that applies to those details. The truth of the case. If you cannot say what you believe happened, you think it could be one of two things, but you're not sure. We've already talked about that is a doubt of the law, and you cannot return a verdict of guilty. The truth in a criminal case is not that you be able to go back there and say A, B, C happened, then D, E, and F happened. The truth of the case is, did the state prove their version and disprove any other defenses? That is what the truth of this case is. And I encourage you, stay true to your oath. I know that y'all will. Like I believe it was Mr. Lewis said, we took a long time picking the jury because we wanted a fair jury. We wanted people who were smart, analytical, that can investigate and look at things and not just say, oh, the last person I hear from, yeah, I'm going to agree with that. We want people that can hear the last person speaking. In this case, it's going to be the state, and go, okay, I hear you, but what would Mr. Clegg have said about that? What would Mr. Lewis have said about that? What would Ms. Drake have said about that? Or what did they say about that? That is part of your job. And most importantly, you know, we ask these questions like, anybody ever supervise people? And I know that may seem like a kind of a crazy question, but being a juror is not easy. Physically, mentally, spiritually. Because as jurors, we need leaders. We need people who make unpopular or tough decisions when the state does not meet their burden of proof. Justice. Everyone wants justice for Bradley Coleman. Everybody wants justice for his mom and his dad and his family and his daughter. But justice in this case is holding Josiah responsible. I'm not asking you to acquit him. I am asking you to hold him responsible, but do that for what he actually did in this particular case, based on the evidence. Justice is holding the state to prove their case beyond a reasonable doubt. Sometimes justice is recognizing charges for what they are. Hijacking a motor vehicle, completely overcharged. All of the gang charges, completely just added in there. Justice is recognizing that questions are not evidence, but sometimes how they play out can be a little bit misleading. For example, State's Exhibit 113. In opening, Mr. Melvin told you that this was a picture of Mr. Booker and Josiah. Did you hear any evidence about that? No. This person was never identified. Does have the same kind of build and a little bit of the hair, but no one identified identified, I don't even know if they identified either of these people. I think it just came off of Mr. Booker's phone, but I don't know that either of them were identified. What's more important is look how little they are. When was this picture taken? Even if you assume this is of Josiah, was this back when maybe he was false claiming? I mean, Josiah looks kind of like a baby now, no offense, but really in this picture, a baby. Nothing to tie it up. Also, he asked Jeremiah, Miles' girlfriend, did you pick up Josiah and Miles when he returned the car? Yes. We know that didn't happen because she said she'd only met him one time, and the state's evidence, all of the phone data, does not put Josiah at that, I believe it was a Turnberry Court address. So when you're back reviewing the evidence, sometimes you may have to think, was that a statement that an attorney made? That is not evidence. And think about what the other evidence in the case has shown. At the beginning, I told you, every death is not a homicide. Every homicide is not murder. Every crime is not just because it is a crime that a gang does. And every crime is not to maintain and increase status, especially when you don't have any social media to post about it on. I hope you remember in my opening, I told you that at the conclusion of the trial, I will come back before you and ask you to return a verdict of not guilty for Josiah based upon the charges. And that is true. I am not asking you to do a complete not guilty in this particular case. I'm asking you to return a verdict that the evidence is uncontroverted about. The truth in this particular case, every homicide is not a murder. In this particular case, it's voluntary manslaughter. I appreciate your time and your patience and your listening. Mr. Melvin will have the last word. I encourage you to give him the same courtesy, but keep in mind, no one over here is going to be able to get up and come back. So think about, what would they have said? What did I hear that gives me a little bit of pause about what is said? And when the verdict comes back, I encourage you to look at all the evidence, hold Josiah responsible. He needs to be held responsible. Trying to do a slider crime, and it goes wrong. But it is voluntary manslaughter. Thank you.
Thank you, Ms. Drake. Okay. We're going to take a 5 to 7 minute comfort break. Thank you. All right, Mr. Melvin?
July 10th, 2022, Bradley Coleman lost his life. And the defendants came to steal. Here's the key thing. They were prepared to kill. This is slowed down. I'm sorry, this is not the slow down one. Up in support. Coming out. Mr. Coleman's dead. He grabs the gun that he dropped. He gets Mr. Coleman's gun that was still in the car. Then he runs back. We're going to see that again in slow motion, just a little bit. But the key thing is, two of the people that you just saw had guns. Mr. Hewley's gun was locked, loaded, and ready to shoot. He brought it to the QuikTrip because he was prepared to kill. He brought the gun out of his car into Mr. Coleman's car because he was prepared to kill. A round was chambered. All he had to do was press the trigger because he was prepared to kill. Mr. Booker, he brought a gun to the QuikTrip. You saw him. He's the man that comes running out, pointing his gun at Mr. Coleman because he was prepared to kill. He ran up in support, pointing that gun. And Mr. Collins, I'm just going to say this. I rented the Benz. He also brought the two gunmen to the QuikTrip and the person that killed Mr. Coleman. We're going to talk about evidence. We're going to talk about the law. Because when you go home and you put your head on your pillow, I want y'all to know you did the right thing. Direct evidence is evidence. This is what the judge is going to charge you that points directly to an issue. You step outside, you feel it raining, you see it raining, you can testify it rained. Circumstantial evidence, on the other hand, is proof by direct evidence from which you can infer other facts. You step outside, the ground is completely drenched. As far as the eye can see, you didn't see it rain, but you can testify it rained while I was at the courthouse. We make decisions all the time based on circumstantial evidence, but here's the other thing. The judge is also going to tell you the law doesn't require any greater degree of certainty for circumstantial evidence. They are equal. So, what about the charges that you have to apply the law to the evidence in this case? Felony murder with the gang acts, aggravated assault with the gang acts, felony murder based on hijacking a motor vehicle with the gang acts, then the hijacking, and then the possession of a firearm during the commission of a felony. Let's talk about those charges because I want you to know you did the right thing. The first one is felony murder based on the aggravated assault. The judge is going to charge you for felony murder. The state has to prove the defendant caused the death of another person by committing a felony. And when you put a gun to somebody's head and shoot, that's felony, and you cause the death. But the judge, well, let's listen to the defendant.
In the car, and when I seen him get up, I tried to get out the car. But by the time when I got in the car, I seen his gun on the passenger seat. So, of course, my first instinct is I'm thinking he was gonna go for his gun. But he started grabbing me and hitting me I didn't hit him back now one time. My whole thing was I was trying to get out the car. I was trying to leave it alone. I even told him during the middle of the incident, I'm telling him out my mouth, I put this on my child, my grandma's life, on everything I love. I'm telling him, I say, okay, get off of me. I'm finna get out your car. I'm like, get off of me. I'm finna get out your car. You got it. My bad. You still just doing the most. It's just like, I don't know how he pushed me out the car. When he pushed me out the car, we fell. He tried to grab his gun, like I knew he was reaching for it. Like, when his gun was on the floor, I knew he was going for it. Like, he was going for his gun. So I'm like, okay, when he grabbed his gun, he's finna shoot me. Even though I told him, like, I know he's finna shoot me. And then, it was how it happened. Like.
So what you're going to see in just a minute when we play the video back in slow-mo is Mr. Coleman didn't go for anything. What you're going to see is that Mr. Coleman's gun was still in the car, and what you're seeing is he was shooting in the head. Remember, they came prepared for this.
Lights.
Mr. Booker is already run around. It's spilling out. Mr. Hewley comes out. He's got a gun in his hand. Because he falls, he comes down, he gets up, bam, Mr. Coleman's dead. Mr. Hewley dropped the gun. Mr. Hewley picks it up. He runs back to the car to get the other gun that was in the car. Mr. Coleman never had his gun. Then Hewley runs away. Defendant, to be accountable for felony murder, is not required to be the shooter. The judge will charge you. A person commits a felony can be convicted for any murder that occurs as the result of the commission of that felony without regard to whether he actually committed, intended to commit, or acts to commit the murder of the victim. That's the law. We hold people responsible for felonies that they commit together. The causation says a person, and the judge in charge of this, commits a felony can be convicted for any murder that occurs during the commission of a felony. That's the law. And we are here today not because of the ills of society, not because of 30 years of rap music. We're here today because of the decisions of the defendants. Their decisions are what put us here today. And they were prepared to kill. The judge is going to tell you that a defendant only need to intend to commit the underlying felony. You may find the defendant guilty of felony murder if you believe that he caused the death of another person by committing the felony of aggravated assault or the felony of hijacking a motor vehicle, regardless of whether they intended that to occur. That's the law. Defense theories. Let's talk about that for a moment. Because I want to be very clear. I am not asking if you're guilty of voluntary manslaughter. Not. Because it doesn't apply. The judge is going to charge you in relation to voluntary manslaughter. In considering felony murder, you must decide whether the defendant was sufficiently provoked and acted out of passion. Then, you're going to have to find 4 things. That they caused the death, under circumstances that would otherwise be murder, and acted only because of a sudden, violent, irresistible passion that resulted from serious provocation. Mr. Coleman was fighting for his life. That holding the arm, watch the video when you see it again in slow-mo, he was holding the arm that had the gun. He was, Mr. Hewley was not seriously provoked. The defense theory, mistake of fact, I think the implication was that the defendant thought he was about to be shot, but mistake of fact is not a defense to a crime. And the judge will tell you this, because it's the law. If the mistake is brought about by the defendant's fault, it doesn't apply. They came prepared to kill. Now, let's talk about some of the defense theories too, because we've talked about reasonable doubt. And my grandfather, he had this saying, you can't make chicken salad out of chicken food. What do you do when you have clients that are just guilty of sin? Then you start saying, they didn't prove their case. There's something missing. You cannot definitively say this is a $1 bill because it says on honor. But ladies and gentlemen of the jury, you are charged with deciding this case beyond a reasonable doubt. Not beyond all doubt. You'll never hear that. It's beyond a reasonable doubt. The doubt of a fair-minded, impartial juror, honestly seeking the truth. Not doubt, but truth. And are there gaps? Always. In every case. But you have the evidence. Defense theory. They didn't tie him to that specific Mercedes. Well, we saw Mr. Hewley get into the Mercedes 350. You heard two witnesses say we scoured that time frame and there was only one Mercedes 350 in the entire scouring that we went through. It had the headlight assembly and a tag reader. We checked flock. It was the only Mercedes. So by the way, it was the flock that showed up at the Texaco the night before. You have Mr. Collins' statement when Detective Harrison says, is this you? Yeah, that's me. That's the clothes I'm wearing. And it was at the Texaco, the same Texaco that hit on a flock camera with the same license plate. Ladies and gentlemen, you can't prove it. It's not a theory. It's a game. And we did prove it. With confession, DNA, with cell data. Oh, Mr. Melvin makes up the word digital DNA. I did say it's like digital DNA. Because the cell phones have unique IMEI numbers that tied to their phones that showed that they were together, that tracked their movements. We did prove it. So let's keep on with the charges because we've talked about felony murder and we'll talk about gang charges towards the end. Person commits the offense of aggravated assault when he assaults another person with a deadly weapon. Assault and aggravated assault. Let me take the law school real quick. So what's an assault? Because we hear about assault and battery all the time. So let's just say you and I are squared up to fight. And as I throw my punch towards you, the apprehension that you have of, I'm about to get hit, that's the assault. I am in immediate apprehension of receiving a violent injury. If I make contact, it's either battery or simple battery, depending on the damage. When I assault someone, but with a deadly weapon, that makes it an aggravated assault, and you have it in this case right here.
It was not even supposed to be the outcome at all. Like
We know, man. Everybody kept saying that. We know
maybe,
that.
maybe an aggravated assault or something, but death, like it's just like the way it happened.
It was
The
fast.
movements,
The blink of an eye.
the movements, it just happened so fast. Like
Even the defendant himself, aggravated assault. It's just going to charge you a firearm. We use its ordinary manner is always a deadly weapon. Then we move to firearm based on hijacking a motor vehicle. You can find the defendant guilty of a felony murder if you believe he caused the death of another person by committing the felony of hijacking a motor vehicle regardless of whether he intended his death to occur or not. So let's talk about hijacking a motor vehicle. Because if a person commits the offense of hijacking a motor vehicle when that person, while in possession of a firearm, it doesn't say use, it says possession, obtains a vehicle from the presence of another individual or attempts to do so, there's no requirement that it be successful. He was in possession of a firearm. Mr. Coleman says, no, you're not. You're not going to. And that obtaining, it took place from the moment that he went into the car until the moment that he started to run away. He was trying to get that car, and he had a firearm. So let's talk about what else that was hit on. A commercially commits the offense of hijacking a motor vehicle when in possession of a firearm. They obtain a motor vehicle or attempts to do so. Obtaining can be temporary, but it can also be the attempt to obtain. When he went into that car with the firearm, Mr. Coleman started to fight for his life, held onto his arm. Ladies and gentlemen, we have hijacking a motor vehicle. So let's talk about possession of a firearm during the commission of felony. And it is what it says it is. If you're using a firearm while you're committing a felony, whether it's ag assault or motor vehicle hijacking, you got possession of a firearm during the commission of a felony. And we saw what that firearm did. So the evidence. The slide I started out at the beginning. I'll show it to you again because I gave you what I promised I'd give you. Just like you do as a shooter, you know it because of DNA. You know it because of confession. You know it because you've seen it. Mr. Booker provided support to a fellow gang member by helping to rent the car. You know it because you heard the testimony. You know it because you've got the documents. And he came running out with a gun in support because Mr. Booker was prepared to kill too. And Miles Collins provided support by renting the car, driving to the QT, and then helping him to escape. So let's talk about parties to a crime, because the judge is going to charge you that every person can be convicted as a party to a crime. That person directly committed it, or we're going under B, intentionally helped in the commission of a crime, whether it be hijacking a motor vehicle or aggravated assault. Then you become a party to a crime. Here it is. This does not happen if they weren't hunting together to steal a car. This does not happen if they weren't prepared to kill. The defendant is not required to be the shooter to commit felony murder. A person who either directly or indirectly is a party to a crime, commits a motor vehicle hijacking or ag assault, they can be convicted of a felony murder. And that's what we're asking you to do. Let's talk about knowledge and intent. Because the knowledge aspect of it is not, did I know they were going to commit a murder? The knowledge is, did I know that we were going to commit the underlying felony? Did I go there with the intent to steal? And yeah, when the defendant knowingly and intentionally participated or helped in the commission of that theft, of that hijacking, of that aggravated assault, then yeah. See people get in the car with a gun? Yeah. You're okay with it because the last time you tried to steal a car and you didn't have a gun, a woman kicked your butt. Or help in the commission of it. You're going to have the cell phone analytics. You're going to get to flip through it. And what you're going to see and what you've seen before in the testimony that you heard is is they got in the car, traveled to the forum. And then, when they fled, they got on 285 and went back home, traveling to the forum, taking them away from the forum, helping in the commission of the crime. Helping in the commission of the crime, wearing the same clothes that you had on 36 hours ago with Mr. Collins at the Texaco, which you're wearing 3 days later after a murder, showing your 9 with this little banana clip. So let's talk about the gang charges. Because every one of the predicate acts has a gang charge attached to it. The first thing that you're going to hear about, and you heard about in testimony, is the Iron Triangle. Gang charges are a little bit different. When you have a person who commits a crime, when you have a person who is in a gang, and those are the kinds of crimes that that gang does, when he does that crime, because that's the kind of crime that that gang does, and he's associated with the gang, then you have the gang charges. So, the gang charges, there's 2 ways. There's the participation in gang activity, and then there's doing it to maintain or increase your status. The participation counts are counts 2, 5, 8, 11, and 14, and the judge is going to charge you that when a person, while associated with a criminal street gang, participates in criminal gang activity through the commission of a criminal offense, then that's a gang charge. Participates and associates. What evidence did we have? Well, you heard Corporal Post talk about the Bloods and their violent history, and the first thing that we have to prove is that there is a criminal street gang. We all know about the Bloods. And if they have a subset of 9 Trey or they're a subset of sex and money murder, it doesn't matter because it's the Bloods criminal street gang. The Atlanta Falcons and the Philadelphia Eagles are part of the National Football League, and the members are professional football players. Members of the Bloods, whether you're a 9 Trey or whether you're sex money murder, are Bloods gang members. The second thing we have to prove is that the defendant is associated with a criminal street gang. It is not necessary to prove that they are a member of that gang. And association means what it says, that I associate. It is its common, everyday usage. Defendant Hewley's association. So in 6, 5, the 44, and text the oath. As I lock the bees with my 3 fingers spread, I shall know my purpose as a blazer. I will abide by the 4-5 movement and respect and honor the hierarchy. I pledge my life as a blazer to walk until peace. And then Station 120, more or less a Rolex money counter, repping sex, money, murder. I'm repping. Is he a gang member? By his own words. That picture that Ms. Drake held up had some other interesting things that you heard expert testimony about. Knowing that the 5's associated with the Bloods, knowing that 9 Trey is associated with Billy, knowing that the signs that we're throwing down are all 9 Trey signs, the Insanity Code Section affiliated with the 9 Trey. Is he a gang member? By his own words. Take him at his word. Then we have the social media postings.
You don't say with your baby daddy, no, not to try.
Is he a gang member?
Yo,
it's Lazy. Gabby, Peanut, y'all ready for today? Oh, look at.
The fuck?
I started off early.
Yeah, 3 stacks, Billy gang shit.
The exact same clothes with Mr. Collins. Mr. Collins, who has the red tattoo. We post on Instagram, the guys rapping about 9 tracks.
Billy gang shit. Yeah, real Billy gang shit. But get what? I never get them street laws. Nigga, mind your business, get money, and shut the fuck up, nigga.
So, are they gang members? Take them at their word. Take them at their posting. Take them with their pictures. Here's the third thing I have to prove. The state has to prove that the defendant conductor participated in the alleged predicate act. The offenses of aggravated assault, the hijacking of a motor vehicle, the firearm charges, they're all predicate acts, gang offenses. You can find one of them every time they participated in it by driving to the QT gas station, by putting a gun, by running up in support, by helping them flee. If you can find them guilty of criminal street gang activity. Is this participating? Mr. Booker runs up. And you heard the expert testimony that if you don't support the gang member when they're in a fight, then you're going to get violent. Just run away together. Counts 2, 5, 8, 11, and 14. The last thing I have to prove in relation to those counts is that that was the sort of crime that the gang does, and you heard the expert testimony from Detective Post, the motor vehicle hijackings, felony murders, the aggravated assaults, the firearm offenses are the kinds of crimes gangs do. And you've also heard that each of the defendants have been involved in this before. The difference is, this time, they were prepared to kill. They did it again. Mr. Coleman died. One and a half hours later, Mr. Hewley, who says, didn't mean for it to go down like that, takes a picture of the victim's firearm that he went back to the car to get and is trying to profit. And the way you know it's the victim's firearm, even though you don't have the serial number, you don't have to have the serial number. Sometimes there's unique characteristics that make things special. And the thing that made it special was that little defect right there in the corner, and you see it right there. 90 minutes later. Trying to buy this gun? Send them a picture. So there's a second set of gang charges. Did I participate in gang activity? We know they're in a gang. We know it's the kind of stuff that the Bloods do. But if I'm in the Bloods gang, whether it's sex money murder or whether it's 9 tray, will I get respect? Will I maintain my status? Will I increase my status? That's what we have to show. And Detective Post told you. He's been doing this for 2 years at the very least. And he says, look, I've studied. I've gone to this and this and this and this. I'm certified in that and that and this. The defendants would be expected to put in work, and that felony murder, hijacking a motor vehicle, like assault would maintain and likely increase their status in the gang. Whether they're 9 or 6 money murder. But as a Blood, it definitely does. What other evidence do you have? Well, you have the evidence on the hunt from Mr. Booker's phone, where he goes up to the QT, and yeah, it ends an hour before, but they're active in their pursuit. And you also know that it didn't leave the area until immediately after the murder. You see Mr. Hewley's phone doing the exact same thing at the exact same time because they're in the same car. You see, Mr. Collins' phone, he didn't have that other data turned on, so they turned to CSLI. You know when he left at the exact same time. You know when he got there at the exact same time. Because they were together in the same car with the intent to steal and prepared to kill. And then, after, you have them fleeing together on Mr. Booker's look-to bar. Mr. Hewley tracking it the same way on his phone. Mr. Collins is busy texting his girlfriend, "You need to hurry and pick me up." And they came prepared to kill. They came prepared to steal. As part of those offenses, we have charged them with the murder of Bradley Coleman, with the underlying offenses of hijacking a motor vehicle and for the aggravated assault, for possession of firearm to convicted felon. And yeah, we charge them with gang charges on every single count. Here's what Dr. Martin Luther King said, and I'm shutting this down. And if I've lost your attention, please give it back to me. Dr. Martin Luther King said, "The moral arc of the universe is long, but it bends towards justice." Prophet Amos said, "Let justice roll like a mighty river." But maybe you tend towards the other side. I know we have one juror who's very much into literature, so let's talk about John Donne. In 1612, John Donne wrote, "No man is an island entire unto himself. Every person is a piece of the continent and a part of the main. If a clod be washed away, Europe is the less, just as much as if it was primary. And any man's death diminishes me, because I am involved in mankind. Therefore, never sin to know who the death bell tolls. It tolls for thee." And what John Donne was trying to express is the interconnectedness of us all. I did not know Bradley Coleman. And y'all didn't either. But I'm lesser because he was taken from us. And on July 10th, 2022, Ms. Coleman lost a son. Others lost a coach, a friend, a mentor. Amira lost her daddy. Because the defendants wanted a car. And they were prepared to kill. We lost a voice that day. The voice of Mr. Coleman. Kind of gets back to what Martin Luther King says, that the arc of the universe is long, but it bends towards justice. Because there is a voice we all have. Genesis chapter 4, the first murder that occurred, Cain killed Abel, and the Lord came to him and said, "Your brother's blood cries out to you from the ground." We all have a voice. And the defendants took that voice away. We've held on to that voice for 2 years since July 10th. Ladies and gentlemen, now we give it to you. Please take that voice and speak the truth with it. You know what happened. Don't let a game of the defense. It's not even a real defense. The real defense is, I wasn't there. I didn't do it. I was defending myself.
a Billy world. You just living in it. Remember that.
No. This is Gwinnett County. There's two times when you really get to affect the society that you live in. One is in the voting booth, and the other is in that jury room. Speak the truth. Because this is what happened. Getting out, he's got a gun in his hand. He falls down. It's there. He picks it up. Bam. Mr. Coleman falls dead. He drops it. He picks it up. He has the presence of mind to go back to the Gwinnett file that he wants to sell years later. They did it together. And they were prepared to kill him. On behalf of the Coleman family,
Thank you, Mr. Melvin. We're going to take a 5-minute comfort break, and then we'll move to jury charges. Ladies and gentlemen, I am about to read the law that applies to this case. I just want to let you know that you will have copies of this back in the jury deliberation room when you go back. So you certainly can take notes, but you will have the written document that I'm reading. Ladies and gentlemen, you are considering the case of the state of Georgia versus David Booker, Miles Collins, and Josiah Hewley Jr. The grand jury has indicted the defendants with the offenses of felony murder, violation of Street Gang Terrorism and Prevention Act, aggravated assault, hijacking a motor vehicle, and possession of a firearm during the commission of a felony. The indictment reads, the Bill of Indictment 22B 04072-4, True Bill, October 12, 2022. Count 1. The grand jurors aforesaid, in the name and behalf of the citizens of Georgia, charge and accuse David Jared Booker, Miles Collins, and Josiah Hewley Jr. individually and as parties concerned in the commission of a crime with the offense of felony murder, for that the said accused in the county and state aforesaid on the 10th day of July 2022 did commit the offense of murder when the accused caused the death of Bradley Coleman, a human being, irrespective of malice, while in the commission of a felony, aggravated assault by shooting Bradley Coleman, contrary to the laws of said state, the good order, peace, and dignity thereof. Count 2. The grand jurors aforesaid, in the name and behalf of the citizens of Georgia, charge and accuse David Jared Booker, Miles Collins, and Josiah Hewley Jr. individually and as parties concerned in the commission of a crime with the offense of violation of Street Gang Terrorism and Prevention Act, for that the said accused in the county and state aforesaid on the 10th day of July 2022, being a member of and associated with the Bloods, a criminal street gang, did unlawfully conduct and participate in criminal gang activity through the commission of the offense of felony murder as described in count 1 of this bill of indictment, contrary to the laws of said state, the good order, peace, and dignity thereof. Count 3. The grand jurors aforesaid, in the name and behalf of the citizens of Georgia, charge and accuse David Jared Booker, Miles Collins, and Josiah Hewley Jr. individually and as parties concerned in the commission of a crime with the offense of violation of Street Gang Terrorism and Prevention Act, for that the said accused in the county and state aforesaid on the 10th day of July 2022, being a member of and associated with the Bloods, a criminal street gang, did unlawfully conduct and participate in criminal gang activity through the commission of the offense of felony murder as described in count 1 of this bill of indictment with the intent to maintain and increase his status and position in said gang, contrary to the laws of said state, the good order, peace, and dignity thereof. Count 4. The grand jurors aforesaid, in the name and behalf of the citizens of Georgia, charge and accuse David Jared Booker, Miles Collins, and Josiah Hewley Jr. individually and as parties concerned in the commission of a crime with the offense of aggravated assault, for that said accused in the county and state aforesaid on the 10th day of July 2022 did make an assault upon the person of Bradley Coleman with a deadly weapon, to wit, a handgun, by shooting Bradley Coleman contrary to the laws of said state, the good order, peace, and dignity thereof. Count 5. The grand jurors aforesaid, in the name and behalf of the citizens of Georgia, charge and accuse David Jared Booker, Miles Collins, and Josiah Hewley Jr. individually and as parties concerned in the commission of a crime with the offense of violation of Street Gang Terrorism and Prevention Act, for that the said accused in the county and state aforesaid on the 10th day of July 2022, being a member of and associated with the Bloods, a criminal street gang, did unlawfully conduct and participate in criminal gang activity through the commission of the offense of aggravated assault as described in count 4 of this bill of indictment, contrary to the laws of said state, the good order, peace, and dignity thereof. Count 6, the grand jurors aforesaid, in the name and behalf of the citizens of Georgia, charge and accuse David Jared Booker, Miles Collins, and Josiah Hewley Jr. individually and as parties concerned in the commission of a crime with the offense of violation of Street Gang Terrorism and Prevention Act, for that the said accused in the county and state aforesaid on the 10th day of July 2022, being a member of and associated with the Bloods, a criminal street gang, did unlawfully conduct and participate in criminal gang activity through the commission of the offense of aggravated assault as described in count 4 of this bill of indictment with the intent to maintain and increase his status and position in said gang, contrary to the laws of said state, the good order, peace, and dignity thereof. Count 7, the grand jurors aforesaid, in the name and behalf of the citizens of Georgia, charge and accuse David Jared Booker, Miles Collins, and Josiah Hewley Jr. individually and as parties concerned in the commission of a crime with the offense of felony murder, for that the said accused in the county and state aforesaid on the 10th day of July 2022 did commit the offense of murder when the accused caused the death of Bradley Coleman, a human being, irrespective of malice, while in the commission of the felony of hijacking a motor vehicle by attempting to take a vehicle belonging to Bradley Coleman by force while in possession of a firearm, contrary to the laws of said state, the good order, peace, and dignity thereof. Count 8, the grand jurors aforesaid, in the name and behalf of the citizens of Georgia, charge and accuse David Jared Booker, Miles Collins, and Josiah Hewley Jr. individually and as parties concerned in the commission of a crime with the offense of violation of Street Gang Terrorism and Prevention Act, for that the said accused in the county and state aforesaid on the 10th day of July 2022, being a member of and associated with the Bloods, a criminal street gang, did unlawfully conduct and participate in criminal gang activity through the commission of the offense of felony murder as described in count 7 of this bill of indictment, contrary to the laws of said state, the good order, peace, and dignity thereof. Count 9. The grand jurors aforesaid, in the name and behalf of the citizens of Georgia, charge and accuse David Jared Booker, Miles Collins, and Josiah Hewley Jr. individually and as parties concerned in the commission of a crime with the offense of violation of Street Gang Terrorism and Prevention Act, for that the said accused in the county and state aforesaid on the 10th day of July 2022, being a member of and associated with the Bloods, a criminal street gang, did unlawfully conduct and participate in criminal gang activity through the commission of the offense of felony murder as described in count 7 of this bill of indictment with the intent to maintain and increase his status and position in said gang, contrary to the laws of said state, the good order, peace, and dignity thereof. Count 10. The grand jurors aforesaid, in the name and behalf of the citizens of Georgia, charge and accuse David Jared Booker, Miles Collins, and Josiah Hewley Jr. individually and as parties concerned in the commission of a crime with the offense of hijacking a motor vehicle, for that the said accused in the county and state aforesaid on the 10th day of July 2022 did attempt to obtain a Dodge Charger, a motor vehicle, from the immediate presence of Bradley Coleman by force and violence while in possession of a firearm, to wit, a handgun, and that the said accused did pull up beside Bradley Coleman and enter the vehicle of Bradley Coleman, acts which constitute a substantial step toward the commission of said crime, contrary to the laws of said state, the good order, peace, and dignity thereof. Count 11. The grand jurors aforesaid, in the name and behalf of the citizens of Georgia, charge and accuse David Jared Booker, Miles Collins, and Josiah Hewley Jr. individually and as parties concerned in the commission of a crime with the offense of violation of Street Gang Terrorism and Prevention Act, for that the said accused in the county and state aforesaid on the 10th day of July 2022, being a member of and associated with the Bloods, a criminal street gang, did unlawfully conduct and participate in criminal gang activity through the commission of the offense of hijacking a motor vehicle as described in count 10 of this bill of indictment, contrary to the laws of said state, the good order, peace, and dignity thereof. Count 12, the grand jurors aforesaid, in the name and behalf of the citizens of Georgia, charge and accuse David Jared Booker, Miles Collins, and Josiah Hewley Jr. individually and as parties concerned in the commission of a crime with the offense of violation of Street Gang Terrorism and Prevention Act, for that the said accused in the county and state aforesaid on the 10th day of July 2022, being a member of and associated with the Bloods, a criminal street gang, did unlawfully conduct and participate in criminal gang activity through the commission of the offense of hijacking a motor vehicle as described in count 10 of this bill of indictment with the intent to maintain and increase his status and position in said gang, contrary to the laws of said state, the good order, peace, and dignity thereof. Count 13. The grand jurors aforesaid in the name and behalf of the citizens of Georgia charge and accuse David Jared Booker, Miles Collins, and Josiah Hewley Jr. individually and as parties concerned in the commission of a crime with the offense of possession of a firearm during the commission of a felony, for that the said accused in the county and state aforesaid on the 10th day of July 2022 did unlawfully have on his person a pistol, a firearm, during the commission of the crime of felony murder, a felony, a crime involving the person of Bradley Coleman, contrary to the laws of said state, the good order, peace, and dignity thereof. Count 14. The grand jurors aforesaid in the name and behalf of the citizens of Georgia charge and accuse David Jared Booker, Miles Collins, and Josiah Hewley Jr. individually and as parties concerned in the commission of a crime with the offense of violation of Street Gang Terrorism and Prevention Act, for that the said accused in the county and state aforesaid on the 10th day of July 2022, being a member of and associated with the Bloods, a criminal street gang, did unlawfully conduct and participate in criminal gang activity through the commission of the offense of possession of a firearm during the commission of a felony as described in count 13 of this bill of indictment, contrary to the laws of said state, the good order, peace, and dignity thereof. Count 15. The grand jurors aforesaid in the name and behalf of the citizens of Georgia charge and accuse David Jared Booker, Miles Collins, and Josiah Hewley Jr. individually and as parties concerned in the commission of a crime with the offense of violation of Street Gang Terrorism and Prevention Act, for that the said accused in the county and state aforesaid on the 10th day of July 2022, being a member of and associated with the Bloods, a criminal street gang, did unlawfully conduct and participate in criminal gang activity through the commission of the offense of possession of a firearm during the commission of a felony as described in count 13 of this bill of indictment with the intent to maintain and increase his status and position in said gang, contrary to the laws of said state, the good order, peace, and dignity thereof. Issue and plea of not guilty. The defendants have each entered a plea of not guilty to this indictment. The indictment and the plea form the issue that you are to decide. Neither the indictment nor the plea of not guilty should be considered as evidence. Presumption of innocence, burden of proof, reasonable doubt. Each defendant is presumed to be innocent until proven guilty. Each defendant enters upon the trial of the case with a presumption of innocence in his favor. This presumption remains with the defendant until it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of the offenses charged. No person shall be convicted of any crime unless and until each element of the crime is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of the crime charged beyond a reasonable doubt. There is no burden of proof upon the defendants whatsoever, and the burden never shifts to the defendants to introduce evidence or to prove innocence. When a defense is raised by the evidence, the burden is on the state to negate or disprove it beyond a reasonable doubt. However, the state is not required to prove the guilt of the accused beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. A reasonable doubt is a doubt of a fair-minded, impartial juror honestly seeking the truth. A reasonable doubt is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt, but is a doubt for which a reason can be given arising from a consideration of the evidence, a lack of evidence, or a conflict in the evidence. After giving consideration to all of the facts and circumstances of this case, if your minds are wavering, unsettled, or unsatisfied, then that is a doubt of the law and you must acquit the defendants. But if that doubt does not exist in your minds as to the guilt of the accused, then you would be authorized to convict the defendant. If the state fails to prove the defendant's guilt beyond a reasonable doubt, it would be your duty to acquit the defendant. Grave suspicion. Facts and circumstances that merely place upon the defendant a grave suspicion of the crime charged, or that merely raise a speculation or conjecture of the defendant's guilt, are not sufficient to authorize a conviction of the defendant. Jury, judges of law and facts. Members of the jury, it is my duty and responsibility to determine the law that applies to this case and to instruct you on that law. You are bound by these instructions. It is your responsibility to determine the facts of the case from all of the evidence presented. Then you must apply the law I give you in the charge to the facts as you find them to be. Evidence generally. Your oath requires that you will decide this case based on the evidence. Evidence is the means by which any fact that is put in issue is established or disproved. Evidence includes all of the testimony of the witnesses and any exhibits admitted during the trial. Evidence does not include the indictment, the plea of not guilty, opening or closing remarks of the attorneys, or questions asked by the attorneys. Direct and circumstantial evidence. Direct evidence is that which may be seen or heard or otherwise directly sensed, such as by smell or taste or touch. It may be brought into the court in the form of exhibits or the testimony of direct witnesses to such matters. It is evidence that points immediately to the issue in question. When direct evidence by inference points to an obvious, likely, or reasonable conclusion, even though that conclusion was not directly seen, heard, smelled, tasted, or touched, that is said to be circumstantial or indirect evidence. Circumstantial evidence is the proof of facts or circumstances by direct evidence from which you may infer other related or connected facts that are reasonable and justified in light of your experience. It is evidence that only tends to establish a conclusion in question by its consistency with such conclusion or elimination of other conclusions. Sometimes circumstantial evidence may point to more than one conclusion. To authorize a conviction on circumstantial evidence, the proved facts must not only be consistent with the theory of guilt, but also exclude every other reasonable theory other than the guilt of the accused. The law does not require a higher or greater degree of certainty on the part of the jury to return a verdict based upon circumstantial evidence than upon direct evidence. Whether dependent upon direct evidence or circumstantial evidence or both, the true test is whether there is sufficient evidence or whether the evidence is sufficiently convincing to satisfy you beyond a reasonable doubt. If not, you must acquit. If so, you may convict. There is no rule that either circumstantial or direct evidence is stronger than the other if conflicting. The comparative weight of circumstantial evidence and direct evidence on any given issue is a question of fact for you, the jury, to decide. Credibility of witnesses. The jury must determine the credibility of the witnesses. In deciding this, you may consider all of the facts and circumstances of the case, including the witness's manner of testifying, their means and opportunity of knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, their interest or lack of interest in the outcome of the case, and their personal credibility as you observe it. Expert witnesses. Testimony has been given in this case by certain witnesses who are termed experts. Expert witnesses are those who, because of their training and experience, possess knowledge in a particular field that is not common knowledge or known to the average citizen. The law permits expert witnesses to give their opinions based upon that training and experience. You are not required to accept the testimony of any witnesses, expert or otherwise. Testimony of an expert, like that of all witnesses, is to be given only such weight and credit as you think it is properly entitled to receive. When scientific, technical, or other specialized knowledge might be helpful, a person who has special training or experience in that field is allowed to state an opinion about the matter. But that does not mean you must accept the witness's opinion. As with any other witness's testimony, you must decide for yourself whether to rely upon the opinion. Witnesses attacked. In determining the credibility of witnesses, in determining the credibility of witnesses and any testimony by them in court, you may consider, where applicable, evidence offered to cast doubt upon the credibility or believability of any such witness. Witnesses supported. In determining the credibility of any witness whose credibility has been attacked, as I have described above, and any testimony by him or her in court, you may consider, where applicable, evidence offered to support the credibility or believability of any such witness. Impeachment. To impeach a witness is to show that the witness is unworthy of belief. The credibility of a witness may be attacked by disproving the facts to which the witness testified. Prior statements. Your assessment of a trial witness's credibility may be affected by comparing or contrasting that testimony to statements or testimony of that same witness before the trial started. It is for you to decide whether there is a reasonable explanation for any inconsistencies in a witness's pretrial statements and testimony when compared to the same witness's trial testimony. As with all issues of witness credibility, you, the jury, must apply your common sense and reason to decide what testimony you believe or do not believe. Single witness corroboration. The testimony of a single witness, if believed, is sufficient to establish a fact. Generally, there is no legal requirement of corroboration of a witness, provided you find the evidence to be sufficient. Statement by one defendant at joint trial. Any out-of-court statement made by one of the defendants on trial in this case after the alleged criminal act has ended may be considered only against the person who made the statement, and only if you find that such statement was freely and voluntarily made. If you find that an out-of-court statement was made to the police freely and voluntarily by the defendant on trial in this case, then you are to consider the statement only as against the particular defendant who made it. Video evidence. You have seen videos during this trial. I have directed that parts of some of the videos to be removed for presentation as not to unnecessarily extend the duration of this trial. Removed portions may include periods of dead time, matters bearing no relation to the case before you, or for specific legal reasons that are not proper for your consideration. You are not to draw any inferences for or against either party based on the removal of portions of this video by this court. Additionally, you have seen videos by 2 of the defendants being interviewed by law enforcement officers. I caution you that the declarations or statements of the officers are not evidence, and you should not consider such statement as evidence unless such statements are proven to you by other competent evidence. Defendant's choice not to testify. The defendant in a criminal case may take the stand and testify and be examined and cross-examined as any other witness. You should evaluate such testimony as you would that of any other witness. However, the defendant does not have to present any evidence nor testify. If the defendant chooses not to testify, you may not consider that in any way in making your decision. Statement of defendant. A statement that the defendant allegedly made while in custody has been offered for your consideration. Before you may consider this as evidence for any purpose, you must determine whether the defendant's statement was voluntary, and if the statement was given in custody, whether the defendant was properly advised of his constitutional rights. Voluntariness defined. To be voluntary, a statement must be freely and willingly given and without coercion, duress, threats, use of violence, fear of injury, or any suggestions or promises of leniency or reward. A statement induced by the slightest hope of benefit or the remotest fear of injury is not voluntary. To be voluntary, a statement must be the product of a free will and not under compulsion or any necessity imposed by others. Burden of proof as to voluntariness. The burden of proof is upon the state to establish that the statement was voluntary, that is, freely and willingly made. If you do not find that the statement was voluntary, you may not consider it for any purpose. Constitutional rights. If you find that the statement was made while in custody and as a result of police questioning, you must also determine whether the defendant was advised of his constitutional rights and whether the defendant clearly understood and knowingly gave up such rights. The constitutional rights that law enforcement officers must explain and that the defendant must understand and voluntarily give up before any custodial statement is taken by law enforcement are as follows. Number 1, the defendant had a right to remain silent. Number 2, if the defendant chose not to remain silent, anything he said could be used as evidence against the defendant in court. Number 3, the defendant had a right to consult a lawyer before any questioning and to have the lawyer present with him at all times during any questions. And number 4, if the defendant did not have money for a lawyer would have been provided for him to represent him before any questioning and to be present with him during any questioning. Burden of proof as to rights. The burden of proof is upon the state to establish that the warnings of all rights mentioned were given, that they were understood and knowingly given up by the defendant. Conditions precedent to consideration of statement. If you find, as mentioned above, that the defendant's statement was voluntary and that all of the warnings as to the defendant's constitutional rights were given, that the defendant did understand the meaning of what was said and knowingly gave up such rights, then you may consider it as evidence. If so, then you must apply the general rules for testing the believability of witnesses and decide what weight, if any, you will give to all or any part of such evidence. If you fail to find the defendant was properly informed of these rights and that he understood and gave up those rights, you must disregard the statement entirely and give it no consideration in reaching your verdict except for the purposes of attacking the credibility of the witness. Corroboration defendant's statement. You should consider with great care and caution the evidence of any out-of-court statement allegedly made by the defendant offered by the state. The jury may believe any such statement in whole or in part, believing that which you find to be true and rejecting that which you find to be untrue. You alone have the duty to apply the general rules for testing the believability of witnesses and to decide what weight should be given to all or any part of such evidence. A defendant's out-of-court statement that is not supported by any other evidence is not sufficient to justify a conviction, even if you believe the unsupported statement. However, proof by other evidence beyond a reasonable doubt that the crime alleged has been committed may constitute supporting evidence of a defendant's statement, if any, should you so find. The law does not fix the amount of supporting evidence necessary. You must determine whether or not other evidence sufficiently supports a defendant's statement so as to justify a conviction. If you find that there was a statement made by a defendant that was supported by other evidence, the degree of proof necessary to convict is that you be satisfied of the guilt of the defendant beyond any reasonable doubt. Limiting instructions. Sometimes evidence is admitted for a limited purpose or against some parties and not other parties, or for some counts and not others. Such evidence may be considered by the jury for the sole issue or purpose against those parties only for the counts for which the evidence is limited and not for any other purpose. Evidence of criminal gang activity. In order to prove its case in counts 1, 4, 7, 10, and 13 of the indictment, the state must prove each of the elements of those offenses on which I have previously instructed you, respectively, beyond a reasonable doubt. To prove counts 2, 3, 5, 6, 8, 9, 11, 12, and, let me start again. To prove counts 2, 3, 5, 6, 8, 9, 11, 12, 14, and 15 of the indictment in this case, the state has offered evidence of other offenses of criminal gang activity alleged committed by the accused. You are permitted to consider that evidence for its bearing on any matter to which it is relevant. The defendant is on trial for the offense charged in this bill of indictment only and not for any other acts, even though such acts may incidentally be criminal and may have resulted in a conviction. Before you may consider any other alleged acts not charged in this indictment, you must first determine whether the accused committed the other alleged acts, and if such act was in fact an act of criminal gang activity. If so, you must then determine whether the act shed any light on the elements of the crimes charged in the indictment in this trial. Such evidence is, at most, supporting evidence of some issues and may not, by itself, be the basis of conviction for the case on trial. By giving this instruction, the court in no way suggests to you that the defendant has or has not committed any other acts, nor whether such acts, if committed, prove anything. This is solely a matter for your determination. Identification reliability. Identity is a question of fact for you to determine. Your determination of identity is dependent upon the credibility of the witness or witnesses offered for this purpose. You should consider all of the factors previously charged you regarding credibility of witnesses. Some, but not all, of the factors you may consider in assessing reliability of identification are, number one, the opportunity of the witness to view the alleged perpetrator at the time of the alleged incident. Number two, the witness's degree of attention toward the alleged perpetrator at the time of the alleged incident. Number three, the possibility of mistaken identity. Number four, whether the witness's identification may have been influenced by factors other than the view that the witness claimed to have. Number five, whether the witness on any prior occasion did not identify the defendant in this case as the alleged perpetrator. And number six, the length of time between the crime and the out-of-court identification. Identification burden of proof. It is for you to say whether, under the evidence in this case, the testimony of the witnesses and the facts and circumstances of the case sufficiently identifies this defendant beyond a reasonable doubt as the perpetrator of the alleged crime. It is not necessary that the defendant show that another person committed the alleged offense. If you do not believe that the defendant has been sufficiently identified as the person who committed the alleged crime or a party to it, or if you have any reasonable doubt about such, then it would be your duty to acquit the defendant. The burden of proof rests upon the state to prove, beyond a reasonable doubt, the identity of this defendant as the person who committed the crime alleged in this bill of indictment. Definition of a crime. The defendants are charged with crimes against the laws of the state. A crime is a violation of a statute of this state in which there is a joint operation of an act and an intention. Intent. Intent is an essential element of any crime and must be proved by the state beyond a reasonable doubt. Intent may be shown in many ways, provided you, the jury, believe that it exists from the proven facts before you. It may be inferred from the proven circumstances or by acts and conduct, or it may be, in your discretion, inferred when it is the natural and necessary consequences of the act. Whether or not you draw such an inference is a matter solely within your discretion. Criminal intent does not mean an intention to violate the law or to violate a penal statute, but means simply the intention to commit the act that is prohibited by statute. No presumption of criminal intent. The defendant will not be presumed to have acted with criminal intent, but you may find such intention or the absence of it upon a consideration of words, conduct, demeanor, motive, and other circumstances connected with the act for which the accused is being prosecuted. Presumptions and inferences. Every person is presumed to be of sound mind and discretion, but this presumption may be rebutted. You may infer, if you wish to do so, that, number one, the acts of a person of sound mind and discretion are the product of that person's will, and number two, a person of sound mind and discretion intends the natural and probable consequences of those acts. Whether or not you make any such inference or inferences is a matter solely within the discretion of the jury. Mere presence. A jury is not authorized to find a person who was merely present at the scene of the commission of a crime at the time of its perpetration guilty of consent in and concurrence in the commission of the crime, unless the evidence shows beyond a reasonable doubt that such person committed the alleged crime, helped in the actual perpetration of the crime, or participated in the criminal endeavor. Mere association, guilt by. A jury is not authorized to find a person who is merely associated with other persons involved in the commission of a crime guilty of consent in or concurrence in the commission of the crime, unless the evidence shows beyond a reasonable doubt that such person helped in the actual perpetration of the crime or participated in the criminal endeavor. Parties to a crime. Every party to a crime may be charged with and convicted of commission of the crime. A person is a party to a crime only if that person A, directly commits the crime, or B, intentionally helps in the commission of the crime. Knowledge. Knowledge on the part of the defendant that the crimes of hijacking motor vehicle, possession of a firearm during the commission of a crime, and or aggravated assaults were being committed, and that the defendant knowingly and intentionally participated in or helped in the commission of such crime must be proved by the state beyond a reasonable doubt. If you find from the evidence in this case that the defendant had no knowledge and that a crime was being committed, or that the defendant did not knowingly and intentionally commit, participate, or help in the commission of, and was not a conspirator in the alleged offense, then it would be your duty to acquit the defendant. On the other hand, should you find beyond a reasonable doubt that the defendant had knowledge that the crimes of hijacking motor vehicle, possession of a firearm during the commission of a crime, and or aggravated assault were being committed, and that the defendant knowingly and intentionally participated or helped in the commission of it, then you would be authorized to convict the defendant. Venue. The law provides that criminal action shall be tried in the county in which the crime was committed. In a prosecution in any case in which it cannot be determined in what county the crime was committed, venue is proper and may be proved in any county in which the evidence shows beyond a reasonable doubt that it might have been committed. Venue, that is, the crime was committed in Gwinnett County, is a jurisdictional fact that must be proved by the state beyond a reasonable doubt as to each crime charged in the indictment, just as any element of the offense. Venue must be proved by direct or circumstantial evidence or both. Offenses charged: felony murder. For felony murder, the state must prove that the defendant, number one, caused the death of another person, two, by committing a felony. Felony means a crime punishable by death, imprisonment for life, or by imprisonment for more than 12 months. Causation in felony murder. You may find the defendant guilty of felony murder if you believe that he caused the death of another person by committing the felony of aggravated assault or the felony of hijacking a motor vehicle, regardless of whether he intended the death to occur. There must be some causal connection between the felony and death. Felony murder is not established simply because the death occurred at the same time as or shortly after the felony was attempted or committed. The felony must have directly caused the death or played a substantial and necessary part in causing the death, regardless of when the death ultimately occurred. Defendant not required to be the shooter to commit felony murder. A person who either directly or as a party to a crime commits a hijacking motor vehicle and or aggravated assault may be convicted of felony murder that occurs as a result of the commission of hijacking motor vehicle and or aggravating assault. Lesser offense of murder, voluntary manslaughter. In considering the felony murder charges, you must decide whether the defendant was sufficiently provoked and acted out of passion. If you find this, you may not return a verdict of guilty of felony murder, but you would be authorized to return a verdict of guilty of voluntary manslaughter. The state must prove beyond a reasonable doubt that the offense should not be reduced from murder to voluntary manslaughter. Voluntary manslaughter, lesser included. For voluntary manslaughter, the state must prove that the defendant, number one, caused the death of another person, number two, under circumstances that would otherwise be murder, number three, and acted only because of a sudden, violent, and irresistible passion that resulted from serious provocation, number four, which was sufficient to excite such passion in a reasonable person. If you decide that enough time passed between the provocation and the killing for a reasonable person to have cooled off and regained judgment, then the killing is not voluntary manslaughter. Provocation by words alone. Words alone, no matter how provoking, will never reduce the crime from murder to voluntary manslaughter. However, words coupled with menacing actions, even if they do not amount to physical contact, may be enough to excite a sudden, violent, and irresistible passion in a reasonable person. If you find that the defendant acted from such passion and not from any spirit of revenge, then you would be authorized to return a verdict of guilty of voluntary manslaughter. Contributing to the death of another. When a defendant unlawfully injures another person, you may find that the injury caused the other person's death only if the state proved beyond a reasonable doubt that the injury, number one, was itself the cause of death, number two, directly and significantly contributed to the cause of death, or number three, significantly sped up the death, even though the death would have eventually occurred. Criminal gang activity. The defendant is charged with the offense of violation of Street Gang Terrorism Prevention Act. That offense is defined as follows. A person commits the offense of violation of Georgia Street Gang and Terrorism Prevention Act when that person, while employed by or associated with a criminal street gang, participates in criminal gang activity through the commission of any criminal offense in the state of Georgia that constitutes criminal gang activity. Criminal gang activity means, among other things, not relevant to this case, the commission, attempted commission, conspiracy to commit, or solicitation, coercion, or intimidation of another person to commit any criminal offense in the state of Georgia that involves violence, possession of a weapon, or use of a weapon. In order to prove a violation of the Georgia Street Gang Terrorism Prevention Act, the state must prove beyond a reasonable doubt 4 elements. First, the state must prove that there is a criminal street gang. Second, the state must prove that the defendant is associated with this criminal street gang. It is not necessary, though, for the state to prove that the defendant is a member of the gang. Third, the state must prove that the defendant conducted or participated in the alleged predicate act. Lastly, the state must prove that there is a nexus between the crime committed and the gang, and that the crime was committed to further the interest of the gang. Definition of participate in Georgia Street Gang Terrorism Prevention Act. The purposes of the offense of violation of Georgia Street Gang Terrorism Prevention Act, the term participate can, but does not have to be defined as, number 1, to take part in something and or to share in something. Definition of criminal street gang. Under Georgia law, a criminal street gang means any organization, association, or group of 3 or more persons associated in fact, whether formal or informal, which engages in criminal gang activity. The term criminal street gang shall not include 3 or more persons associated in fact, whether formal or informal, who are not engaged in criminal gang activity. As charged in this case, criminal gang activity means felony murder, aggravated assault, hijacking a motor vehicle, and possession of a firearm during the commission of a felony. The existence of a criminal street gang may be established by evidence of a common name or common identifying signs, symbols, tattoos, graffiti, or attire, or other distinguishing characteristics, including but not limited to common activities, customs, or behaviors. The term criminal street gang, however, does not include 3 or more persons associated in fact, whether formal or informal, who are not engaged in criminal gang activity. Whether a criminal street gang exists in this case is for you, the jury, to decide. Consideration of criminal gang activity to establish criminal street gang. The commission of any offense that would constitute criminal gang activity by any member or associate of an alleged criminal street gang may be considered by you to determine whether the state has proven beyond a reasonable doubt the existence of the criminal street gang and criminal gang activity. Intent to affect gang status. It is unlawful for any person to commit any offense of criminal gang activity as previously defined with the intent to maintain or increase his or her status in a criminal street gang. Whether the state has proven that any defendant in this case committed any such offense and did so with this intent is for you, the jury, to decide. Simple assault, reasonable fear. Such an assault is an act that places another in reasonable apprehension or fear of immediately receiving a violent injury. If there is a demonstration of violence with an apparent ability to inflict injury so as to cause the person against whom it is directed to reasonably fear the injury, then the assault is complete, even though the assailant may never have been within actual striking distance. Aggravated assault with a deadly weapon. For aggravated assault, the state must prove that the defendant, number 1, assaulted another person, number 2, with a deadly weapon. To prove assault, the state does not have to prove that the other person was actually injured. However, the state must prove that the committed act that placed a person in reasonable apprehension or fear of immediately receiving a violent injury. Let me read that sentence again. However, the state must prove that the defendant committed an act that placed the person in reasonable apprehension or fear of immediately receiving a violent injury. Firearm as a deadly weapon. A firearm, when used in the way a firearm is ordinarily used, is a deadly weapon. Justification. The fact that a person's conduct is justified is a defense to prosecute for any crime based on that conduct. The defense of justification can be claimed, A, when the person's conduct is justified under Official Code of Georgia annotated 16.321, 16.323, 16.324, 16.325, 16.326. B, when the person's conduct is in reasonable fulfillment of his/her duties as a government officer or employee. C, when the person's conduct is the reasonable discipline of a minor by his or her parent or person in loco parentis. D, when the person's conduct is reasonable and is performed in the course of making a lawful arrest. E, when the person's conduct is justified for any other reason specified under the laws of the state. Or F, in all other instances based on similar reason and justice as those enumerated in this charge. Justification, use of force in defense of self or others. A defendant is not justified in threatening or using force if he provokes the threat or use of force against himself, intending to use that threat or force as an excuse to harm the other person, is attempting to commit a felony, to wit, hijacking a motor vehicle, a felony, which I will define for you shortly, is the initial aggressor unless he withdraws from the encounter and clearly communicates to the other person his intent to withdraw, and the other person continues or threatens to continue the use of unlawful force. Reasonable beliefs explained. For the defendant's threat or use of force to be justified, 1, the defendant must believe that his threat or use of force is necessary. 2, that belief must be reasonable. That is, a reasonable person would also believe that the threat or use of force is necessary. And 3, the defendant's reasonable belief must be what prompts him to threaten or use force. Mistake of fact. You may not find the defendant guilty of the crime charged if, number 1, the defendant's alleged criminal act, number 2, was caused by a mistake about a fact, and 3, that fact, if true, would have justified the defendant's act. Mistake of fact is not a defense to a crime if the mistake is brought about by the defendant's fault or negligence. Hijacking a motor vehicle. A person commits the offense of hijacking a motor vehicle in the first degree when such person, while in possession of a firearm or weapon, obtains a motor vehicle from an individual or the presence of another individual by force and violence or intimidation, or attempts or conspires to do so. Use of force. The use of the offensive weapon during a hijacking must either precede or be contemporaneous with and not subsequent to the taking. Obtain possession. Obtain means to gain or attain possession, usually by some planned action or method. Therefore, the offense of hijacking a motor vehicle is concluded when possession of the motor vehicle is attained. Possession of a firearm during the commission of a felony. For possession of a firearm during the commission of a felony, the state must prove that the defendant, number 1, had a firearm, number 2, while committing a felony, to wit, felony murder, a crime against or involving another person. Multiple defendants. Though you may consider all of the evidence as a whole, conviction of one defendant does not necessarily require conviction of another or all. You, the jury, must determine the guilt or innocence of each separately. Verdict, generally. If, after considering the testimony and evidence presented to you, together with the charge of the court, you should find and believe beyond a reasonable doubt as to count 1, that the defendant in Gwinnett County, Georgia, did on or about July 10, 2022, commit the offense of felony murder as alleged in the indictment, you would be authorized to find the defendant guilty. In that event, the form of your verdict would be, we, the jury, find the defendant guilty. If you do not believe beyond a reasonable doubt that the defendant is guilty of felony murder, then you would be authorized to find the defendant guilty of voluntary manslaughter, and the form of your verdict in that event would be, we, the jury, find the defendant guilty of voluntary manslaughter. If you do not believe that the defendant is guilty of the offense of felony murder or the offense of voluntary manslaughter, or if you have any reasonable doubt as to the defendant's guilt, then it would be your duty to acquit the defendant, in which event the form of your verdict would be, we, the jury, find the defendant not guilty. If, after considering the testimony and evidence presented to you, together with the charge of the court, you should find and believe beyond a reasonable doubt as to count 2 that the defendant in Gwinnett County, Georgia, did on or about July 10, 2022, commit the offense of violation of Street Gang Terrorism and Prevention Act as alleged in the indictment, you would be authorized to find the defendant guilty. In that event, the form of your verdict would be, we, the jury, find the defendant guilty. If you do not believe that the defendant is guilty of the offense of violation of Street Gang Terrorism and Prevention Act, or if you have any reasonable doubt as to the defendant's guilt, then it would be your duty to acquit the defendant, in which event the form of your verdict would be, we, the jury, find the defendant not guilty. If, after considering the testimony and evidence presented to you, together with the charge of the court, you should find and believe beyond a reasonable doubt as to count 3 that the defendant in Gwinnett County, Georgia, did on or about July 10, 2022, commit the offense of violation of Street Gang Terrorism and Prevention Act as alleged in the indictment, you would be authorized to find the defendant guilty. In that event, the form of your verdict would be, we, the jury, find the defendant guilty. If you do not believe the defendant is guilty of the offense of violation of Street Gang Terrorism and Prevention Act, or if you have any reasonable doubt as to the defendant's guilt, then it would be your duty to acquit the defendant, in which event the form of your verdict would be, we, the jury, find the defendant not guilty. If, after considering the testimony and evidence presented to you, together with the charge of the court, you should find and believe beyond a reasonable doubt as to count 4 that the defendant in Gwinnett County, Georgia, did on or about July 10, 2022, commit the offense of aggravated assault as alleged in the indictment, you would be authorized to find the defendant guilty. In that event, the form of your verdict would be, we, the jury, find the defendant guilty. If you do not believe that the defendant is guilty of the offense of aggravated assault, or if you have any reasonable doubt as to the defendant's guilt, then it would be your duty to acquit the defendant, in which event the form of your verdict would be, we, the jury, find the defendant not guilty. If, after considering the testimony and evidence presented to you, together with the charge of the court, you should find and believe beyond a reasonable doubt as to count 5 that the defendant in Gwinnett County, Georgia, did on or about July 10, 2022, commit the offense of violation of Street Gang Terrorism and Prevention Act as alleged in the indictment, you would be authorized to find the defendant guilty. In that event, the form of your verdict would be, we, the jury, find the defendant guilty. If you do not believe that the defendant is guilty of the offense of violation of Street Gang Terrorism and Prevention Act, or if you have any reasonable doubt as to the defendant's guilt, then it would be your duty to acquit the defendant, in which event the form of your verdict would be, we, the jury, find the defendant not guilty. If, after considering the testimony and evidence presented to you, together with the charge of the court, you should find and believe beyond a reasonable doubt as to count 6 that the defendant in Gwinnett County, Georgia, did on or about July 10, 2022, commit the offense of violation of Street Gang Terrorism and Prevention Act as alleged in the indictment, you would be authorized to find the defendant guilty. In that event, the form of your verdict would be, we, the jury, find the defendant guilty. If you do not believe the defendant is guilty of the offense of violation of Street Gang Terrorism and Prevention Act, or if you have any reasonable doubt as to the defendant's guilt, then it would be your duty to acquit the defendant, in which event the form of your verdict would be, we, the jury, find the defendant not guilty. If, after considering the testimony and evidence, if, after considering the testimony and evidence presented to you, together with the charge of the court, you should find and believe beyond a reasonable doubt as to count 7 that the defendant in Gwinnett County, Georgia, did on or about July 10, 2022, commit the offense felony murder as alleged in the indictment, you would be authorized to find the defendant guilty. In that event, the form of your verdict would be, we, the jury, find the defendant guilty. If you do not believe beyond a reasonable doubt that the defendant is guilty of felony murder, then you would be authorized to find the defendant guilty of voluntary manslaughter, and the form of your verdict in that event would be, we, the jury, find the defendant guilty of voluntary manslaughter. If you do not believe that the defendant is guilty of the offense of felony murder or the offense of voluntary manslaughter, or if you have any reasonable doubt as to the defendant's guilt, then it would be your duty to acquit the defendant, in which event the form of your verdict would be, we, the jury, find the defendant not guilty. If after considering the testimony and evidence presented to you, together with the charge of the court, you should find and believe beyond a reasonable doubt as to count 8, that the defendant in Gwinnett County, Georgia, did on or about July 10, 2022, commit the offense of violation of Street Gang Terrorism and Prevention Act as alleged in the indictment, you would be authorized to find the defendant guilty. In that event, the form of your verdict would be, we, the jury, find the defendant guilty. If you do not believe that the defendant is guilty of the offense of violation of Street Gang Terrorism and Prevention Act, or if you have any reasonable doubt as to the defendant's guilt, then it would be your duty to acquit the defendant, in which event the form of your verdict would be, we, the jury, find the defendant not guilty. If after considering the testimony and evidence presented to you, together with the charge of the court, you should find and believe beyond a reasonable doubt as to count 9, that the defendant in Gwinnett County, Georgia, did on or about July 10, 2022, commit the offense of violation of Street Gang Terrorism and Prevention Act as alleged in the indictment, you would be authorized to find the defendant guilty. In that event, the form of your verdict would be, we, the jury, find the defendant guilty. If you do not believe that the defendant is guilty of the offense of violation of Street Gang Terrorism and Prevention Act, or if you have any reasonable doubt as to the defendant's guilt, then it would be your duty to acquit the defendant, in which event the form of your verdict would be, we, the jury, find the defendant not guilty. If after considering the testimony and evidence presented to you, together with the charge of the court, you should find and believe beyond a reasonable doubt as to count 10, that the defendant in Gwinnett County, Georgia, did on or about July 10, 2022, commit the offense of hijacking a motor vehicle as alleged in the indictment, you would be authorized to find the defendant guilty. In that event, the form of your verdict would be, we, the jury, find the defendant guilty. If you do not believe the defendant is guilty of the offense of hijacking a motor vehicle, then you would be authorized to find the defendant guilty of theft by taking, and the form of your verdict in that event would be, we, the jury, find the defendant guilty of theft by taking. If you do not believe the defendant is guilty of the offense of hijacking a motor vehicle, or you have any reasonable doubt as to the defendant's guilt, then it would be your duty to acquit the defendant, in which event the form of your verdict would be, we, the jury, find the defendant not guilty. If after considering the testimony and evidence presented to you, together with the charge of the court, you should find and believe beyond a reasonable doubt as to count 11 that the defendant in Gwinnett County, Georgia, did on or about July 10, 2022, commit the offense of violation of Street Gang Terrorism and Prevention Act as alleged in the indictment, you would be authorized to find the defendant guilty. In that event, the form of your verdict would be, we, the jury, find the defendant guilty. If you do not believe that the defendant is guilty of the offense of violation of Street Gang Terrorism and Prevention Act, or if you have any reasonable doubt as to the defendant's guilt, then it would be your duty to acquit the defendant, in which event the form of your verdict would be, we, the jury, find the defendant not guilty. If after considering the testimony and evidence presented to you, together with the charge of the court, you should find and believe beyond a reasonable doubt as to count 12 that the defendant in Gwinnett County, Georgia, did on or about July 10, 2022, commit the offense of violation of Street Gang Terrorism and Prevention Act as alleged in the indictment, you would be authorized to find the defendant guilty. In that event, the form of your verdict would be, we, the jury, find the defendant guilty. If you do not believe that the defendant is guilty of the offense of violation of Street Gang Terrorism Prevention Act, or you have any reasonable doubt as to the defendant's guilt, then it would be your duty to acquit the defendant, in which event the form of your verdict would be, we, the jury, find the defendant not guilty. If after considering the testimony and evidence presented to you, together with the charge of court, you should find and believe beyond a reasonable doubt as to count 13 that the defendant in Gwinnett County, Georgia, did on or about July 10, 2022, commit the offense of possession of a firearm during the commission of a felony, as alleged in the indictment, you would be authorized to find the defendant guilty. In that event, the form of your verdict would be, we, the jury, find the defendant guilty. If you do not believe that the defendant is guilty of the offense of possession of a firearm during the commission of a felony, or if you have any reasonable doubt as to the defendant's guilt, then it would be your duty to acquit the defendant, in which event the form of your verdict would be, we, the jury, find the defendant not guilty. If after considering the testimony and evidence presented to you, together with the charge of the court, you should find and believe beyond a reasonable doubt as to count 14 that the defendant in Gwinnett County, Georgia, did on or about July 10, 2022, commit the offense of violation of Street Gang Terrorism and Prevention Act, as alleged in the indictment, you would be authorized to find the defendant guilty. In that event, the form of your verdict would be, we, the jury, find the defendant guilty. If you do not believe the defendant is guilty of the offense of violation of Street Gang Terrorism and Prevention Act, or if you have any reasonable doubt as to the defendant's guilt, then it would be your duty to acquit the defendant, in which event the form of your verdict would be, we, the jury, find the defendant not guilty. If, after considering the testimony and evidence presented to you, together with the charge of the court, you should find and believe beyond a reasonable doubt as to count 15 that the defendant in Gwinnett County, Georgia, did on or about July 10, 2022, commit the offense of violation of Street Gang Terrorism and Prevention Act, as alleged in the indictment, you would be authorized to find the defendant guilty. In that event, the form of your verdict would be, we, the jury, find the defendant guilty. If you do not believe that the defendant is guilty of the offense of violation of Street Gang Terrorism and Prevention Act, or if you have any reasonable doubt as to the defendant's guilt, then it would be your duty to acquit the defendant, in which event the form of your verdict would be, we, the jury, find the defendant not guilty. This court has no interest in this case. By no ruling or comment that the court has made during the progress of the trial, has this court intended to express any opinion upon the facts of this case, upon the credibility of the witnesses, upon the evidence, or upon the guilt or innocence of any of the defendants. Sympathy. Your verdict should be a true verdict based upon your opinion of the evidence according to the laws given you in these charges. You are not to show favor or sympathy to one party or the other. It is your duty to consider the facts objectively without favor, affection, or sympathy to either party. In deciding this case, you should not be influenced by sympathy or prejudice because of race, creed, color, religion, national origin, sexual preference, local or remote residence, economic status for or against either party. Sentencing. You are only concerned with the guilt or innocence of the defendant. You are not to concern yourself with punishment. Deliberations. One of your first duties in the jury room will be to select one of your number to act as foreperson, who will preside over your deliberations and who will sign the verdict to which all 12 of you freely and voluntarily agree. You should excuse me. You should start your deliberations with an open mind, consult with one another, and consider each other's views. Each of you must decide this case for yourself, but you should do so only after a discussion and consideration of the case with your fellow jurors. Do not hesitate to change an opinion if you are convinced that it is wrong. However, you should never surrender an honest opinion in order to be congenial or to reach a verdict solely because of the opinions of other jurors. During your deliberations, you must not communicate with anyone other than your fellow jurors about this case. You're also not permitted to conduct any research about this case, including persons, places, or legal concepts mentioned during trial. These rules apply not only to in-person communication, but also to communication or research using cell phones, text messaging, websites, blogs, or social media of any time. Unanimous verdict. Whatever your verdict is, it must be unanimous. That is, agreed upon by all. The verdict must be in writing and signed by one of your members as foreperson, dated and returned to be published in open court. You will receive a verdict form for each separate defendant. State, does the state have any objections to the reading of the jury charges?
No, ma'am.
Does the defense have any objection to the reading of the jury charges?
I don't have any objection, Judge. I think there's one thing we might want to take up outside
Yeah,
the presence of the jury.
Yeah.
I have two objections, and they need to be taken up outside the presence of the.
Okay, all right. I'm going to release you for a break. You're not to start deliberations until I resolve this matter. We're off the record. Ladies and gentlemen, I made my office and I made a mistake on charging you under verdict generally regarding count 10. So I'm going to recharge that. If after considering the testimony and evidence presented to you, together with the charge of the court, you should find and believe beyond a reasonable doubt as to count 10, that the defendant in Gwinnett County, Georgia, did on or about July 10, 2022, commit the offense of hijacking a motor vehicle as alleged in the indictment, you would be authorized to find the defendant guilty. In that event, the form of your verdict would be, we, the jury, find the defendant guilty. If you do not believe that the defendant is guilty of the offense of hijacking a motor vehicle, or if you have any reasonable doubt as to the defendant's guilt, then it would be your duty to acquit the defendant, in which event the form of your verdict would be, we, the jury, find the defendant not guilty. With that recharge and all the objections noted, are there any further objections to the reading of the jury charges? Depends.
No, ma'am.
Okay. All right, ladies and gentlemen, it is now in your hands. Since it is 5:15, y'all can stay a little while, maybe select a poor person, or you can elect not to stay at all and come back tomorrow morning. That's just up to you. You just let the bailiffs know what y'all decide. You can stay till 10 o'clock. We'll bring you dinner. It's totally up to you. So you can just let them know what y'all want to do collectively, and we'll go from there. Thank you. It'll take us a few minutes to get all the evidence back there. Okay. Yes, all your notes. Take all your notes with you. They're going to stay in the jury room with you.